Hello, hello. We have internet again. Welcome back in. I'm going to continue the hearing in just a couple of minutes. Spectrum, spectrum, spectrum. We are live. Hello, Potato. Let's give this another round. Let's give it another try. Hey, Jubes. Welcome back, everybody. Hello. Sorry about that. Spectrum had like some kind of weird outage. Welcome back. Hey, Lady Tiger. This is going to be called part 2 of the Bryan Kohberger motion hearings. So without further ado, I'm just going to go ahead and continue. I rewound about 30 seconds because I know we buffered out. So thank you, Lucia. Thank you, Evelyn. Thank you, guys. All right, here we go.
My question that will be before a jury, what does that mean, right? What does a knife sheath at a scene mean? That's going to be the ultimate question. You're
killed by a knife, it probably means a lot.
It might mean a lot.
Probable cause is not a proof beyond a reasonable doubt standard. There's probable cause to think that this person might have done it. And I'm not sure how that direct DNA connection to a sheath found on or near one of the victims doesn't
Welcome back, guys.
close the book on anything on probable cause after that.
Well, I think it doesn't close the door on probable cause. I think when you know the other factual information that the magistrate should have known, I think that there's a lot of pause even at a probable cause level, Judge. This was information withheld from the magistrate, and I'm talking about, let's just go with the car. Let's just go with.
I understand the lack of evidence of DNA material or other victim-related material in the car in his apartment as asserted, but I'm not sure how that precludes probable cause when there's a direct DNA match. There's plenty of reasons that might be the case. And when a magistrate's looking at this, they have a direct DNA match to a person from a object likely associated with a murder weapon. I have not yet a magistrate would not find that probable cause.
Tammy,
The
click
magistrate
that.
had the other facts. I think the magistrate would have some
Chris.
serious concerns and would not find probable cause. Your Honor, the vehicle, and I know the court knows what I'm going to say. There's not DNA in that vehicle that was brought out from a crime scene. This absolutely matters, Your Honor. If you want to go to the state's theory, right, with their videos that they've talked about, that they told the magistrate about, that this is the video, this is what matters. It parks at this certain time, it leaves at this certain time. If you want to go to that, there's about 13 minutes of time, right? 13 minutes between the last time you see the car and the next time you see the car on the video. And if you end up with a car that's searched, and I mean searched and taken apart, the brake is taken apart, the gear shift is taken apart.
Look at the judge.
The key fob is checked. There's no blood on any of that, none. The steering wheel, there's some kind of spray all over the interior of the car to check for it. There's no blood. I think that there's context that the magistrate should have known that's absolutely exculpatory to Mr. Kohberger, and it matters a whole lot.
I'm not saying it's not potentially exculpatory. I'm just saying I'm not sure how knowing that in light of a positive DNA connection would cause any magistrate to say, well, okay, I guess there's no probable cause here because you couldn't find other connection to forensic evidence when there are other things in the affidavits at that point that could explain that, including the use of covering clothing and covering gloves and all that could be put into a bag real quick on the way out that was in one of the affidavits. I guess, and I don't intend to argue with you about it. I understand your other arguments, but when you get to once they have the actual DNA, evidentiary DNA, it seems to me that it's an uphill battle to say there's not probable cause at that point.
Well, Your Honor should never get to that question, but I'm going to answer it for you. But you should never get to that question because you should have already found that AT&T 1 and AT&T 2 were terrible, and there's no probable cause for those, and they just build on each other. So you should find that the very first one lacked probable cause, and then everything else does as well. But let me answer your question there. If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters. And then maybe the car being completely empty of any blood DNA connection, maybe that matters a little bit more. Maybe
Well, I'm just not sure why it matters for probable cause, but I think we're talking over each other, so I'll let you just go on.
Okay. I don't think probable cause is in a vacuum. I think probable cause isn't one thing. I hope it's not one thing. I hope there has to be a little bit more than one thing, especially when you've got another thing that's the same as the one thing.
Well, I said I wouldn't do this, but I'm going to do it anyway, because you brought up blood DNA of an unknown individual that was found, I think, on the handrail.
Yes.
Doesn't that necessarily not exclude Mr. Kohberger? What it may do is suggest there might be a potential other person in addition involved if you assume that that blood was related to the victims and not some earlier event in the house.
What the court is saying is exactly why the magistrate needed to know that. Is there another explanation here? I've got this sheath, but there are all these other things that if I know about them, matter. What's the other explanation? What's going on with this investigation? What's happening here? That's exactly the point, Your Honor. What other explanation is there? The magistrate wasn't given a chance to ask that. She wasn't given a chance to ask that when she wasn't told about unknown male B, blood on the handrail. She wasn't given a chance to ask about that when she wasn't told about unknown male D, blood on a glove right outside the residence. She wasn't given a chance to ask any of those questions. She didn't know that Bryan's car and the court's question, good question, what does that mean? Could it mean there's more than one person? The answer to that is, or it could mean it's not Bryan because his car's got nothing in it and there were only 13 minutes to do this. The magistrate didn't get to know that.
In fact, his DNA is still on the knife sheath, though. That's the problem, counsel, for probable cause purposes.
We're right back to square one.
If that's the only thing she's told, I can see why she'd find probable cause. It's these other things that are withheld that create a context around it. I think the purpose of Frank's is to ask this very question. This is a question. What do we want to do with our criminal justice system? Do we want to have one thing with no context around it when there's this other context that really matters?
Applying the Frank standard, which is even if you add that stuff, does that take away probable cause, counsel? And my problem is once you have a direct DNA tie to the defendant, for purposes of probable cause, this isn't for purposes of conviction, for purposes of probable cause, you have not explained to me why a reasonable magistrate, let alone any magistrate, wouldn't find probable cause there, even if they knew all those other facts.
Welcome back, guys. Hopefully the internet stays on.
As to Mr. Kohberger, now, there may be, as you say, other people that creates concern or issues about that need to be investigated further. But I'm not sure that that diminishes the probable cause as to Mr. Kohberger if his DNA is found on a knife sheath found on or near the victim who was stabbed with said alleged knife that would have been in said alleged sheath.
I think the most prominent question is how did that sheath get there? And I think when you ask that question, I think you can have DNA on an object at a scene when you know about all of these other things and you don't find probable cause, because there are more questions than there are answers, and all of a sudden this one thing doesn't look as big. It doesn't look as everything pointing to it when you have the context around it. The magistrate didn't have to have every detail of the case, but knowing how many attempts to find a DNA connection there were, and it didn't exist, in Bryan's car, in Bryan's apartment, that there's no other DNA in there other than an unknown male B that we know of for sure, an unknown male D outside. There's a lot of context there, and all of a sudden this one thing, the question of how is that there, is the question that the magistrate should have had. And then we come to all of the other things that we've talked about. We've come to what we relied on. One of the witnesses saying things that absolutely couldn't be true. One of the things that the witness who said these things that couldn't be true also admitted she didn't really know anything. You can't rely on that anymore, so you take that out. You know the identification to this sheath that maybe seems like it would be really good. You don't really even know how that happened, and you don't know how it got there. This isn't like DNA in blood on the wall from Mr. Kohberger. That's not there. That doesn't exist in this scene. You're talking about an item that the question of how should be, especially when you know about the other male DNA in the house, and especially when you know about the lack of DNA connections.
Hey, Sin. Hey, Shell. Hey, Misty.
There's also
Tilt
no
a whirl
connection between the people in the house and Mr. Kohberger based on their cell phones, based on social media accounts. There's just no connection. The magistrate wasn't aware of all of those factors when she was being asked to decide on probable cause. I don't think criminal justice means one piece of evidence out of the context of everything else is all you need. Context matters a whole lot.
Well, you're not suggesting the magistrate was told that there was DNA evidence found in Mr. Kohberger's car or in his apartment. The lack of inclusion also can be viewed as the implied of, they're obviously not telling me they found this when they would have if they did.
I'm not 100% sure I followed. I'm not sure. Are you asking me why I think that's important as far as the Frank's purposes?
Well, for Frank's purposes, you are implying, I think necessarily, that the police intentionally didn't tell the magistrate that they didn't find the lack of evidence in other places, the apartment, the car, etc. Right?
Yes, that's right.
They didn't tell the magistrate
Exactly, Flutter.
that there was evidence. This is a omission.
This is one of the omissions, yes. Yes, we have false statements and we have omissions both. It's not one
Hey,
thing
Pine.
in this case.
I was understanding completely.
Yeah, thank you for that. I wasn't following the question the court was asking. I think the other thing, I think I covered all on my proffer, Your Honor. Thank you. Sorry.
I think now,
Hey,
is Tyler
Cheryl.
going to address the IGG Franks issue, or is Ms. Jennings going to cover all of it?
Your Honor, I think I'm going to cover all of it.
All right, let's do it, Miss Jennings. Miss Jennings, Ashley Jennings from the prosecution. Thank you so much, Sophia, for gifting a membership.
As you're well aware, you have to make two separate inquiries for each of the claims that Ms. Taylor has brought before you. First, you have to decide today, has the defendant made a substantial, not just a preliminary showing, but a substantial preliminary showing that the affidavits, and in our case, we're referring to the Exhibit A's that were attached to each of the affidavits for probable cause, that they were the basis, which were the basis for multiple search warrant applications, that within those Exhibit A's, there were deliberate or recklessly false statements or omissions. This is a high burden, and this is a very high hurdle for them to jump over.
Pine.
Now,
The
if you can
90s?
answer yes to that, then and only then should we move on. And then ask the second question, does that even matter? Does that statement actually diminish the probable cause finding? It's only when the answer to both of those questions is yes, should you then even consider granting a Franks hearing. The motion for a Franks hearing is a serious allegation. The allegation is that law enforcement acted improperly, that they lied to the magistrate in order to secure the warrant. The statements have to be deliberate, reckless, false. That's the standard. Franks is not implicated by just simple mistakes or misunderstandings about the evidence, or Scrivener's errors, or even just negligence. As the court is well aware, this is serious. The defendant is alleging law enforcement lied to secure the probable cause in this case. And the state submits the defendant has failed to back up this claim, and they failed because they can't. Law enforcement submitted probable cause affidavits to the magistrate based on the information they had available to them at the time that the various applications were made. That's how it's supposed to work, and that's how it worked. The defendant has alleged 13 separate areas where they say there's a Franks violation. I'm going to go through those so that I make sure that I get through each of them in the same order that defendant addressed them in their motion and as the state addressed them in our response. And that starts with this idea of attacking Exhibit A. As the court knows, in Latah County, it's our practice, we submit an affidavit for probable cause. As I said, attached to that affidavit is what we call an Exhibit A. That Exhibit
Thank you,
A
Melissa.
is law enforcement officers' statements, laying out all the various facts known to them related to probable cause in order to support the issuance of a search warrant. In this case, Exhibit A, by the time we get to where we're challenging, was about 20 pages of facts for the magistrate to review. Essentially, the same Exhibit A was relied upon for the application of multiple warrants. This was a massive investigation. You heard testimony earlier today from Detective Payne. Multiple officers were involved in this investigation from multiple agencies. And they were doing briefings. For weeks at a time, they received 2 briefings a day with all the lead investigators in the same room receiving the same information. This information was then put into this Exhibit A for the basis of a probable cause affidavit for search warrants.
Exhibit E.
A working document like this, with the most up-to-date information, was the best way to ensure the magistrate was getting the most complete and accurate information. And defendant wants to take issue with this process. But
What do I do if the affidavit is attached to Detective A's submission, is Detective A's affidavit, right? And there's a, for purposes of my question, a material reckless statement in there. But Detective A isn't the one that made it. It was another person on the team, let's say the cast member expert.
well,
How does that affect the Franks analysis as it relates to the affidavit submitted by Detective A?
I would say that Detective A would have to have reason to know that that was a materially reckless statement made by Detective B.
Oh,
Even
no.
if the person that made the statement on the team knows that that statement going into the affidavit, the group affidavit, if you will, or the group statement is going to ultimately make its way to the magistrate?
I'll concede I think there's an issue there, but that's not what happened. I don't think that any officer can submit a statement that they know is going to go in front of a magistrate and do so recklessly. And if they do so, then I agree. That has to, the court should take issue with that. But the cooperative nature of this investigation and this kind of group effort is allowed. As discussed more extensively in the state's response, we have several Idaho cases that support this. State v. Rubio, State v. Gomez, State v. Alger. And in our case, the probable cause affidavit.
But what did Detective B do? So the probable causes were written by Brent Payne and Blaker. So Payne and Blaker. So Detective B made some kind of a comment.
It wasn't as if the judge wasn't put on notice.
Look at Payne's in the look. There's Payne. There's Brett Payne. Look. Oh my God. Check it out. Look at there's little Brett Payne right there on the end. I don't know who these other people are, but that certainly is little Brett Payne. So is Brett Payne Detective B? And if so, what the hell did he do or say? Yeah, that's little Brett Payne up there. He is a tiny little fellow. He's magically delicious.
That this was exactly what was happening. The judge was put on notice. Each affidavit explicitly told the magistrate, blank officer, depending on who was applying for it, quote, is being assisted by members of the Idaho State Police and agents of the Federal Bureau of Investigations. Throughout the document, it makes references. I consulted with FBI Vehicle Specialist S.A. Imel. I consulted with FBI SA Balance regarding CAST. I consulted with FBI SA Hill regarding surveillance footage. It's very clear what the sources of the information were coming from. It could absolutely be reasonably inferred where the information was coming from. The magistrate was not at all misled regarding the sources of all the information. I'm going to talk a little bit about this idea that there's some issue with who did the work in reference to Google. They claim that the CSLI work alleges Kohberger around the King Road residence. And this same claim is in Exhibit A signed by Detective Blaker. Well, this is inaccurate.
She
the
said
officer signing the affidavit did not claim to do the CAST work.
Hold on. She just named Blaker. I don't see Blaker there, though. I want to hear that again.
In Exhibit A signed by Detective Blaker. Well, this is inaccurate. The officer signing the affidavit did not claim to do the CAST work.
Did you mean?
Thanks,
AT&T?
Cheryl. I'm cold.
Yes. They didn't claim to have gotten those records and put them into their program to determine the approximate locations of the phone. That was done by Special Agent Balance. And the affidavit makes that clear.
Balance.
And defendant ignores the entire paragraph within Exhibit A that makes that clear. Quote, I consulted with an FBI special agent that's a certified member of CAST. This paragraph goes on to explain what CAST is, what CAST does,
She's
the experience
annoyed.
that's involved, SA Balance's own experience. And then the law enforcement officer then states, from information provided by CAST, I was able to determine estimated locations for the 8458 phone. That's not claiming to have done the CSLI work, but instead is just a reflection. The work was done by Balance, investigators reviewed that, and then made some determinations of the approximate locations for that 8458 phone. And we're going to get into this in a little bit down because this comes up again. All about the cell phone. And we're just going to take
Look at Bryan.
We have two different opinions
God.
about what those records show. We have an expert who tells us, and that's what was relayed in the probable cause affidavit. And those opinions haven't changed.
Thanks for sharing, Kimmy.
We differ on a few factual issues. I believe there are
I'll
three
sleep
towers
better
that
tonight
provide
knowing
service
that.
to the Moscow area. Defendant is cool.
Here's my concern with you telling me that at this stage of things. Where in the record is that currently?
Ooh.
Apart from anything you may have submitted after they filed the Frank's motion.
Tell us, Ashley.
What specifically?
That there are 3 towers.
I believe I referenced it in my response.
Well, yeah, but that doesn't, if you give me evidence and I rely on that evidence, then I have to give them a full Frank's hearing. And so that's why I've been very clear to say I'm looking at what the proffer is from the defense without evidence submitted by the state
Come on,
to
Jennings.
determine whether they have met their threshold burden. And so I get concerned when you start telling me things that are not necessarily part of the evidence.
Understood. We can we can move past the number of towers. Here's what is in evidence, though.
Tell us.
And based off of the PC affidavit, is that the phone was in the area for the tower that provides service to the 1122 residents. Still maintained.
Crickets.
That's true. Regardless, none of this has any bearing on the validity of the search warrant. Their argument is merely a clarification about which member did what work. And that doesn't matter to the ultimate determination for probable cause. Defendant then makes some allegations regarding an eyewitness statements related to DM. There's kind of two buckets of attacks here. The first bucket is that the defendant claims the magistrate was never informed that DM told law enforcement she, when shown a picture, didn't recognize the defendant. What clear from reading the probable cause affidavit that she's not going to recognize the defendant.
What relevance was the statements of DM that were included in the affidavit as to probable cause?
I cited those in my response throughout.
What were they?
Okay. I can tell you generally, consistently, she gave the same set of facts.
I understand the things she said. Why was it important the magistrate know those things? In other words, are
They're
they going
used to
who the
judge,
idea
judge,
of the perpetrator
guys.
is? Are they going to establish a timeline of when the alleged or when the murders took place?
Both.
So it's part ID as well?
I think that it goes to giving a general description of the person that she saw in the residence around the time that corroborates when we know these crimes occurred. Yes, a general description is material and relevant. And that general description, which is what was provided in the PC affidavit, was consistent throughout all of her interviews. She described seeing someone wearing all black, a mask with only invisible. This person was male. White.
Why does it keep doing that?
She only invisible, wearing all black, a mask with only invisible.
See, why is this weird like this? Why is she skipping when this was live?
This person was male, white. She heard a voice that was not something that she recognized. The person was a slim, skinny, lean build. And the person was taller than she is around 5'8". That's what's important. It was that general description.
Yeah, my internet's fine. But you know what's crazy is that you guys have to remember that Ashley Jennings is used to presenting her cases in front of Judge. And what's that other lady? The one that looked like she was 20 years old, the first lady with the bubble letters, the one that wrote with bubble letters. Those are the judges they're used to going up in front of. Now they're in Boise. They're not in little old frickin' Latah County. So I think it's interesting to see, them perform in front of this judge, if you will, because I really like this judge.
And that general description did not change.
Is it also important to establish the timeline?
It is. It's important to establish the timeline to know when the timeline matched the vehicle surveillance of when a suspect vehicle is coming into the area of 1122 and then leaves, as well as text communications of her relaying what she's observing during the same time period.
And that lady's sitting there smiling the whole time. It's like, what?
And even if the state's wrong, that somehow there was some exculpatory relevance to some of her statements not being included in the probable cause affidavit, you can take all of it out and the magistrate would still have probable cause. The second issue the second kind of bucket that they take issue with DM, is about these other just statements that she gives during interviews.
Tell us, Ashley.
The defendant argues when an eyewitness states she's not sure anything she saw was real, a magistrate should know about it. Well, the simple answer is investigators knew what she saw was real, and we know it wasn't a dream because they found the evidence discovered the next morning. Those statements didn't need to be included in the PC affidavit because they weren't exculpatory. They didn't support this idea that this didn't really happen, that somehow we got it wrong. Next, defendant attacks the vehicle identification.
Look at the judge, y'all.
Well, this picture they're painting about how
Hi, Jeff.
how this happened just is simply not true. The magistrate was given a very detailed picture of the investigation at the time related to the white sedan, which was later determined to be a Hyundai Elantra. This was about 5 pages of the probable cause affidavit. The reality is, yeah, still images and video were provided to a vehicle specialist. Based on his review, he provided information to investigators that the suspect vehicle was likely a Hyundai Elantra. There was some discussion regarding what was the most appropriate year range, but at the specialist's direction, he said that the year range to be focused on was 2011 to 2016. So Detective Payne reasonably relied on his expertise as a vehicle specialist and included that.
Detective Payne? We're relying on Detective Payne for this? Detective Payne was not the specialist, was he? By the way, if you're just joining, see little Detective Payne sitting in the back, in the top right square in the suit. He's magically delicious. What's up, Florida Bass? We didn't, Lindsay. Nope. That's little Payne up there, right?
And his on was 2011 to 2016. So Detective Payne reasonably relied on his expertise as a vehicle specialist and included that in his probable cause affidavit.
No, are you kidding me? Detective Payne? Little Brett Payne? And he's adjusting his suit as she says that. Dude, I thought the expert was from the FBI. Oh, I haven't watched it. This is my first watch around, Jeff. He gets on the stand. Let's keep going.
And the court has in front of it the emails attached as exhibits that show that's exactly what occurred. And the defendant appears to argue that, well, the vehicle specialist shouldn't have relied on this video because they can't tell that that was a Hyundai Elantra. To them, it doesn't look like, I guess, a Hyundai Elantra. And the video that is clear, well, they take issue with that video because, and specifically we're talking about 1125 Ridge Road, because they say, well, that can't be surveillance video of the white Elantra, even though it was caught on video about 0.3 miles from the crime scene, about 3 minutes right before when we see the suspect vehicle enter the area of the crime scene, which 0.3 and 3 minutes appear to be the amount of time it would take the vehicle to travel to the area of the crime scene. They say, well, that can't be the right video because if it were, then the surveillance right up the street would have also caught this video. But we know that's not true.
That's okay, Jeff.
And that's been submitted to this court. Excuse me?
When was it submitted to this court?
Well, it was submitted through my response.
I was afraid you were going to say.
It was submitted through my response that their logic is flawed. And I can tell you, it has since been confirmed. I do not have, and it has been discovered to defense. We had Special Agent Hill confirm, and he discovered this as Bates 15990, which confirms that the surveillance camera that was set up to capture motion would not have captured the corner the defendant says must have been necessarily captured. Again, it doesn't matter. At the end of the day, the defendant's speculation about the route of travel and their differing opinion on it isn't the basis for a Franks hearing. There's no legal basis for second-guessing a vehicle specialist's opinion, and they haven't made a substantial or sufficient proffer for you to do that. Next, the briefing addresses the IGG issue.
Is it possible to tell from the affidavit what shots and what cameras were relied upon to make the identification?
I know that I don't know that you needed to. I don't know that all of that information had to be included.
That wasn't my question. My question is whether the affidavit describes the specific shots and cameras relied upon to make the identification.
No.
Pocket, no, then
It discusses
See ya.
that several surveillance videos were reviewed.
see ya.
That images were turned over to a vehicle specialist, and then that specialist made a determination. But no, we didn't walk through describing each and every still image or video to the magistrate. No, nor did we need to. Really, the IGG has been discussed extensively. I think the only real Franks issue is, should the IGG process, the fact that it was not included in the PC, is that the basis for a Franks hearing? But you heard testimony today that law enforcement received this tip, and they made a strategic decision not to include it. We're told it's only a tip, and that they should develop probable cause
Just the tip.
separately. And that's what they did. And at the end of the day, Your Honor has already kind of hit the nail on the head through your questioning of Ms. Taylor. At the end of the day, this information regarding IGG and the use of IGG is only inculpatory. And the non-reliance on the IGG information does not diminish probable cause. And the IGG information was confirmed through the STR testing. I can't wrap my head around any argument that IGG and STR testing would be exculpatory. Defendant makes kind of hay about the dog barking, and that I guess the magistrate should have been informed that a dog barked for 25 to 30 minutes. And this is just a reach for me. I'm still unclear how this is exculpatory. And again, this fact just does not diminish. Take out all information related to the dog. It doesn't diminish probable cause. Circling back to the cell phones, at the end of the day, the proffer is their opinion of the evidence. That's not the basis for a Franks hearing. We're relying on our expert's opinion. They disagree.
Those are their assistants.
And that is a dispute that should be had, and it should be had at trial. And I suspect it will. But it doesn't give you the basis to grant a Franks hearing. And the next area is the footprint. There was a footprint found outside of DM's bedroom. They claim that the inclusion of this was misleading. But again, there's nothing misleading about the statement. The statement says during the process of the crime scene, the investigators found a latent shoe print. It was located during the second processing. It came back using a presumptive blood test and showed the presence of cellular material. They let the judge know that it was outside the door to DM's bedroom, located on the second floor, and it's consistent with her statements. Yeah. The investigators provided the magistrate the information they had at the time of the investigation. Defendants' opinions about where the shoe print should have been located, and it couldn't necessarily have been located there, again, that just doesn't rise to the level to warrant a Franks hearing. Again, our case doesn't hinge on the identification of the shoe print. Neither did the PC affidavit. There was sufficient probable cause with or without this information. I'm going to address grand jury subpoenas. They didn't discuss it today, but it's addressed in their motion.
Before we get to that, can you address the allegation that the cell phone data was, I guess, purposefully erroneous as to the...
Ooh, we're going to get to the erroneous cell phone data. Jeff H., thank you so much. Good to see your face, boy. I haven't seen you in so long. Jay, I posted a new one that explains why I think it's hard to determine the year of the Elantra at night. Check it out when you get a sec. Thank you so much. We definitely will, Jeff. Thanks.
Time that the phone was no longer reporting, which then relates to the supposed position of travel.
Right. Well, I don't know that I completely wrap my head around the defendant's logic in this.
I have to, so help me out.
Well, I still don't
I
understand.
understand her statement and her argument. I'm trying to understand your response.
I guess what was reported was the information known at the time that the probable cause affidavit was given.
By
There's
Spain? Or by
the
cast
information
member?
that he was given from.
This goes to my first question about imputed erroneous statements. So I understand the allegation in that regard, not necessarily to be that Detective Payne knew the statement was wrong, because I'm not sure there's evidence of that. But did the cast specialist know that there was a misinterpretation or an erroneous report?
I don't think that you have before you a sufficient proffer that proves that the cast specialist submitted false information. Apparently, there's a difference in the handoffs of 7 minutes. At the end of the day, okay. No, I don't think it's incredibly material.
Okay.
Is it material if you look at it in terms of where the phone
She
was
said-
in that 7 minutes?
Well, it's material.
Going a direction different than what your affidavit says it was going, isn't that material?
The direction of travel, like, yes, I would say it was if it was found outside of Pullman. It was not. It was reporting to a tower in Pullman. This assumption assumes that cars can't change direction of travel. We're assuming that then the same cell phone, which was then turned off, isn't then also tied to the evidence where we do have information to believe a white sedan tied to Mr. Kohberger is then found on surveillance. We're not talking about 7 minutes. We're talking about 7 minutes at 2:50 in the morning, which is about an hour, approximately a little over an hour before the crimes occurred. I don't follow the logic that this 7 minutes, an hour and 10 minutes prior, proves that there's no way the defendant couldn't have traveled the 7 miles to Moscow, whether or not the car was pointed in a different direction or not. It's a leap for me. Does that answer?
Well, it's your answer, so.
Did you see her?
Let's say
These people are so out of their league. This judge is awesome. Watch her face. She's like, does that answer it? And she smiles. Hey, Beans, she might be able to smile at Megan Marshall or Judge, and Judge will just give her this blank look, right? Watch this interaction again. This is funny as shit.
Does that answer?
Well, it's your answer, so.
Let's say it was. Let's say that it was exculpatory. Let's say it was that it was false. It was recklessly included. It wasn't, but let's say it was. Well, the magistrate still had enough information before her to grant probable cause for the arrest. So we still don't get to a Franks hearing, even if you want to make that leap.
Leapfrog.
I can quickly go through grand jury subpoenas. At the end of the day, their desire still, this has come up several times throughout this process, their desire to see the actual grand jury subpoenas is not the basis for a Franks hearing. There's just simply no legal basis to support that idea. And there is nothing obtained that was obtained in violation of any of the defendant's constitutional rights. They say they needed to know the scope, but it is not clear to the state how that would have made any difference in the probable cause determination or why the magistrate would need to know that. Again, this just appears to be another attempt by the defendant to try to obtain these federal grand jury subpoenas. And I submit to you, Franks is not the proper avenue. We're going to go to lack of connection. I think this has already been addressed by Your Honor. At the end of the day, this fact just has no bearing on the probable cause determination. The investigators relayed the known information they had at the time, and timing is important. At the time of the application of most of the warrants, the evidence taken from the defendant and his vehicle was still being reviewed. We didn't know if there was a connection. Only a few warrants even fell outside of that. Apple, YouTube, Instagram, TikTok, PayPal, and Microsoft. However, Even for those warrants, the state submits to you that fact's not necessarily exculpatory. The defendant's belongings and the vehicle were recovered approximately 6 weeks after the homicides. And that fact was known in the probable cause affidavit. It could be reasonably inferred. But to the extent the court believes that law enforcement should have included this information, again, I can accept that, but it's not enough to outweigh the balance of the information that was included that did establish probable cause. I submit to you that the defendant has wholly failed to establish a single false statement or omission without which the magistrate would not have found probable cause. I ask that you deny their motion for a Franks hearing. Thank you.
Okay.
Well,
Random fun fact about Santa. He does do Santa. Like, his Instagram is him dressing up as Santa. It's like his side job. Can't make it up.
briefly.
Here we go. Anne's back.
Okay.
Guess who's back?
I'll try to do my part to make you so that
Back
you can
again.
avoid asking questions unless I truly stumped.
to say to Ann C. Taylor?
Before I get started on what I want to tell you, in response to what the state said and in my summary, I'm curious about the new police report that was talked about. I didn't see it in the submission given to Your Honor.
I've had such an avalanche, I can't think of what it is off my head. If it did, it certainly wouldn't be part of the analysis for the court in determining whether or not you've met your showing to have a Franks hearing.
Well, that's good, because it occurred after my Franks briefing came, so I didn't get a chance to respond to that yet. All right, let's start with the grand jury subpoenas.
Let's do it.
Yeah, we wanted those in discovery. We didn't get those. We were told no a couple of different times. The issue with that is that at least one of the warrants was used, the returns from the grand jury subpoenas, it used the return from the grand jury subpoena to obtain information, and we don't have those, so we don't know the scope and parameters of that, so the magistrate relied on something that's not reviewable by us, and that's kind of gotten to be...
Amazon.
Sorry?
Is that Amazon?
It is Amazon, Your Honor, and the return on the search warrant says that they already produced them pursuant to something else, and the affidavit says,
Bryan.
we saw these things, so now give them to us in a search warrant. That just seems to be problematic to me. It's kind of the same thing that's laying on pretty thick here. You can't have it. We're not going to tell you about it, but don't worry, we didn't do anything wrong. And that's a problem. That's a theme of this case, and that's really a problem. So I think we should have Frank's hearing to explore what that really is about, if for nothing
The
else.
omission, or the statement that you're, as it relates to the Amazon warrant.
The omission is the FBI used the grand jury system and obtained this information outside of the warrant process, but for some reason, we need to come and get a warrant because nobody gets to. I have them in other cases, Judge. I don't know why they're withheld here. It makes me really suspicious.
I mean, I guess from a Frank's perspective, though, the question is, was there a material, intentional misstatement or reckless misstatement?
From Frank's perspective, was it material? Well, it was relied on to get the warrant, right?
It disclosed to the magistrate that this was the result of information given as a result of a federal grand jury.
It absolutely was.
What did they say that was not true, or what did they fail to disclose?
I think they failed to disclose the parameter around that grand jury subpoena.
How is that? Well, I understand. I promised I wouldn't slow you down, so I'm going to let you just go ahead.
Okay.
True crime.
Um,
I know, me too. It gives me the creep. Gives me the creeps.
I'll go backwards. The 7 minutes that's not disclosed, that's intentional.
Look at
but
Ashley
that's
Jennings.
Not given to the magistrate to make the decision.
Look at Ashley.
There are a lot of these things that are intentional withholdings and a lot of things that are deliberate. You heard a lot earlier today about the hours of meetings that took place and the decisions to keep certain things secret. So I think we've satisfied the prong of deliberate and intentional withholding from the magistrate or deliberate false statements to the magistrate on all of those areas. I want to talk only about a couple of other things. The credibility of the witness that they talked to, the one that they cited information from, that was relied on. That appears in these affidavits, and it's relied on after Mr. Kohberger's identified to say, well, he has bushy eyebrows, so this person has to be right. It's relied on when the police
Damn
officers put
eyebrows.
into the affidavit the footprint that I didn't talk about on my first one. We gave the court the photographs of it. I'm happy to give the court these. That's a misleading statement to the court or to the magistrate that was asked for probable cause. This footprint is at the very edge of the door. It's a single footprint, and it's not repeated throughout the house. So to act like that bolsters this witness is really important, especially in context of the misstatements of the witness.
Wait a minute, Anne. What'd you just say?
That's a misleading statement to the court or to the magistrate that was asked for probable cause. This footprint is at the very edge of the door. It's a single footprint, and it's not repeated throughout the house. So to act like that bolsters this witness is really important, especially in context of the misstatements of the witness. I want to go through these. I won't read them in their entirety to the court, but Your Honor asked the prosecutor what they were. And I counted up, and at the very first interview, remember the issue was whether or not one of the victims ran downstairs, and she didn't say it once. She said it.
Thank you, Flo. Thank you so much for the pet therapy. I see her loving you, priceless. Oh, I wondered if you guys could see her over here. Summer, say hello. This is pretty wild. What's Payne doing back there?
To the court, but Your Honor asked the prosecutor what they were. And I counted up, and at the very first interview, remember the issue was whether or not one of the victims ran downstairs, and she didn't say it once. She said it 4 times in a row in the very first interview, and that just didn't happen. It just couldn't have happened, and that was not told. In fact, that statement was brushed over and withheld from the magistrate. About the memory issues in the second interview.
One of the victims went up and down the stairs and said that twice.
The same day, there are 2 references to not remembering.
I remember clove cigarettes.
A couple of days later, there's the third interview, and there's references to not remembering, being drunk, a statement, I don't know any of it. Like half this stuff. I don't know if it's a dream or if it's real. That's at page 399. At page 406, I don't know if this was real or in my mind was just like playing with me. But from what I think I heard, someone was crying in the bathroom. These are definite statements that were not given to the magistrate, and in fact were brushed over. And credibility, just like playing with me. But from what I think I heard, someone was crying in the bathroom. I don't know if this was real or in my mind was just like playing with me. But from what I think I heard, someone was crying in the bathroom. I don't know if this was real or in my mind was just like playing with me. But from what I think I heard, someone was crying in the bathroom. These are definite statements that were not given to the magistrate, and in fact were brushed over.
Do you remember that the upstairs bathroom was right above Dylan's room? She thought she heard someone crying in the bathroom. Holy fuck,
Over. And credibility is really, really important when that person is relied on in the investigation. So let's talk about the vehicle. The court asked some questions about what the magistrate could see in the PC affidavit. The way it's laid out would cause one to think that the vehicle is identified on the camera near the house, and that's not so. It's not identifiable. The state's expert said it's not identifiable from that particular video. It's piecing together the other videos that they come up with something.
What's the evidence that law enforcement relied on the Ridge Road footage to identify the vehicle?
What did they rely on?
What's the evidence that they relied on Ridge Road, which you say doesn't show anything? What's the evidence they relied on that to ID the vehicle?
maybe, well,
They relied on the Ridge Road camera, and you can see that in
maybe it was from Xana's bathroom then. Maybe it was the bathroom by Xana.
the emails from IMO and the other law enforcement officers when they say they have Paradise Creek Road, and then they say we finally got a good one, and it produced to us is the 1125 Ridge Road footage and photograph, and that's the only one that you can make a positive ID on the car.
Where is that in the record?
The 1125 Ridge Road, well, it's in our discovery.
Or is it in the motion?
I believe we put a picture of that in our motion. I can look at it's in my original memorandum. I think there's a picture of that. Let me grab that page for you.
We're almost done with this one, and then we move on to the next one. Seems like that upstairs would have echoed, doesn't it, Jeff? Like that stairwell?
I believe it's on page 17 of the amended memorandum.
That's just the photograph?
Yes.
But not the information that ties that to the Ridge Road camera?
Your Honor, it's tied by our argument based on our review of the discovery. I don't have an affidavit from any police officer saying it was that. I probably don't have an email other than the ones from Immel and that transaction that we did provide for the court, that was the video that the identification was made on. That, I'd love to know more about that as well, Your Honor.
Oh, but that's not the standard.
I understand that. I would refer the court to our exhibit with Agent Immel's communication. I believe that is going to be at D9, and then the pictures contained in the Frank's motion. Let me talk a little bit more about IGG, even though we've done that all day long today. I would remind the court that IGG doesn't identify a person. It suggests a family group, and an investigation can happen from there, but nothing happened until the IGG happened behind the scenes and in a closet. That brings me to talk about the intentionalness of this in an overview. And the court should look at the entire picture of what's happened. It's a long investigation. It's a complicated investigation, but you have law enforcement repeatedly meeting, and you have FBI agents sprinkled in. And there are a lot of things that you've heard about today that are withheld, that are super secret, that nobody's going to talk about. And there's a lot of meetings that are happening, particularly around the IGG. That's a definite. We're not going to put that in there. But there's also the communication about the AT&T records, about what do those phone records mean? What does it mean when there's calls being handed off, or phone tower reporting being handed off to track a vehicle? What does that mean? There's communication about that. There's review of the videos together. What these things mean is that a partial picture was decided upon, a picture that left out a lot of detail, a picture that gave false statements to the magistrate to get probable cause to get that first AT&T warrant. That was, the officers went back and forth talking about what kind of statements to use. Statements were changed to be included in that, and definite decisions were made at that time. The decision was made to leave the witnesses' statements in as they were, even though there had been interview after interview after interview, and they knew those were incorrect. The decision was made to build a false investigation and leave out the super secret IGG part. And that decision was made based on the behavior of the agents and based on not wanting anybody to review what they did,
secret
so that we could check their work and see if they did
agent
anything right. That just continued with decisions to leave things out in this case. Probable cause doesn't get determined by one little thing without context, especially when there's context of omitted information. That's why we have the opportunity for a Franks hearing, to ask for a Franks hearing and to offer information for your Honor to rely on. It is imperative that there be integrity in the warrant process. There's a lot of power in going to a magistrate and having no attorney there, nobody to cross-examine, nobody to question. There's a lot of power in that to obtain a warrant. And there's a lot of danger when there's that much power too. To leave just a little out here, to add a little more here, and go get a warrant, and then build everything that comes from that. And that's what's happened here. Your Honor, we ask for a Franks hearing to more fully explore these. The court can see this is a massive amount of information. The court has 1,000 pages. These aren't just pages that we made up. There's a lot going on here, and we need to have a hearing to fully explore this. Thank you.
All right, we will take the GG under advisement. I will under advisement, issue opinions on those forthwith. We will pick up tomorrow with, I'm trying to think, we're probably got the evidence on the motions to suppress tomorrow, correct?
Yes, Your Honor.
All right, I'll see you in the morning.
All right. So now we are caught up from yesterday because I didn't watch this. We learned those few new things, right? So now we're going to move on to today. Here we go. And you know what? Lucky you. You don't have to wait. No waiting here. Let's fast forward to when we get some action here. Thank you guys for joining. So apparently Brent Payne takes the stand, I guess. So here we go. They're going to open it up to us right meow.
Your Honor. First,
Hang on a second.
oh, sorry.
I haven't called us to order
Oh,
yet.
I am so sorry. I thought you said, sorry.
I said, let's bring the public in.
Okay.
Oh my God. They have it. Did you guys catch that?
Your Honor. First,
Hang on a second.
oh, sorry.
I haven't called us to order
Oh,
yet.
I am so sorry. I thought you said, sorry.
I said, let's bring the public in.
Okay.
I appreciate the eagerness, though. All right, are we broadcasting, Sandra? All right, this is a continued hearing in State v. Kohberger, CR 0124316665. Defendant is again present with counsel Ms. Taylor and Ms. Massoff. The state is present, represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. This morning's hearing will discuss the motions to suppress and any evidence related thereto, as well as we'll get into the argument on that. So with that, I understand the parties are prepared to proceed. The defense, do you have witnesses to call this morning?
We do, Your Honor. We have two.
All right, who's your first witness?
Corporal Brett Payne.
All right, let's get going with that then, if Corporal Payne would step forward. You were sworn yesterday, as I recall, but we'll go ahead and do it again just for formality's sake.
Here we go.
Good morning.
Morning, ma'am.
Could you please state your name and spell your last for the record?
Brett Payne, last is spelled Payne.
And what's your title?
I'm the Detective Corporal for Moscow Police Department.
Can you tell the court, I know you testified yesterday, but it was a different hearing, and so just to lay a little bit of foundation, can you tell the court your background in law enforcement?
So I've been with Moscow Police Department for almost 7 years now. Prior to that, I was in the active duty military for 6. 3 of those were as a commissioned officer in the Military Police Corps.
What is your role in this case?
I was assigned lead detective in this particular investigation.
And so, as lead detective, can you explain from your perspective what that has meant that you have done?
Certainly. So it was my responsibility to basically view this investigation from a 30,000-foot view, if you will. Directly, it's the teams that were assigned to various tasks, and then taking all that information, synthesize it, put it back out to our group, and then eventually consolidate it into an affidavit.
And in terms of that affidavit, yesterday there was some discussion and testimony about that and how it was created. Would you explain that?
Absolutely. So the information was brought to us via various teams and specialists in their particular areas. For instance, most of the cell phone stuff was covered by Special Agent Balance from the FBI. All that information was brought to the team, relayed back out at least twice a day, and then as that information was essentially synthesized, it was put into a running document, a living document that is now known as Exhibit A.
So when it was characterized yesterday as a group effort, do you agree with that characterization of it?
Yes, ma'am.
And do you know approximately how many warrants you worked on in this case?
I don't, ma'am. Several. I don't know the exact number.
Right. I'm going to walk you through several segments of different warrants, and some of this may seem choppy, but I'm going to try to do you and then Detective Mowry at once instead of bringing you back and forth. Does that make sense?
Yes, ma'am. Sounds good.
All right. And Judge, I have paper exhibits for you and for the witness, and so I'll go as fast as I can, but I want you to be able to look at what he's looking at. So we're going to begin with the first AT&T warrant. Prior to this case, had you ever secured an AT&T warrant?
No, ma'am. I don't believe I had.
And so, given that, who did you rely on in creating the warrant for
Largely
AT&T?
Special Agent Balance. Obviously, he's the CAS expert, so I relied heavily on his input.
At the time that AT&T warrant 1 was secured, were you co-located with Special Agent Balance?
I believe so, yes.
Can you, well, in terms of being more specific, it was December 23rd. Were you two co-located at that time?
I believe so, yes.
And I know co-located has been talked about in court a couple of times, but can you just explain what it means for you two to be co-located since he's from DC?
Certainly. Yeah, he was in the same building as I was, just mere feet away from the command post.
Okay, so when you say mere feet away, were you guys in like a cubicle setting, or were you in offices with doors? What was this setting in terms of proximity to each other a few feet away?
Yeah, separate offices with doors, but in the same second floor of the Moscow Police Department.
Are you aware of Special Agent Balance in his work in doing AT&T records, having any access to AT&T records without a warrant?
I'm not aware of that, no.
Are you aware of him having any ability to review AT&T records through any portal without a warrant?
Not to my
knowledge. Hey, did he say he's never written a warrant before this case? Look at Brian. He doesn't like Brent Payne.
knowledge, no.
Logston's yawning.
I'm going to begin with what is known as State's Exhibit 1, attached to their objection to the motion to suppress AT&T warrant. And Judge, for today's purposes, what I'm doing is relying on the labels that are in the record as opposed to giving them new stickers.
This has been marked previously as States S1, or is that 8-1? I can't.
I think it's SS for State 1.
All right, States S1 affidavit for search warrant.
And now I've got to get...
Objection to the admission of that for today's hearing.
You know, Judge, I should have started out by saying that the same stipulation regarding the admission of all exhibits applies today.
We do need the formality of moving for the admission, however. So that's why
I can do that. Do you want me to do that per exhibit?
well, it makes, if you, as you're talking about them, it probably makes sense.
Okay, I've got to get myself S1. Okay, Detective Payne, can you look at page 5?
Yes, ma'am.
On page 5, can you read what it says in at the very end of the page, in the sentence above wherefore, that begins with, the paragraph, it begins in support. Can you read that paragraph?
Certainly. In support of the assertion as to the existence of probable cause, the following facts are offered based upon personal knowledge of affiant. See attached statement of Brett Payne, which is marked Exhibit A and incorporated as though fully set forth herein.
Thanks,
And
Potato.
is that S1 the affidavit in support of the search warrant?
Yes, it is.
And that's the AT&T 1 search warrant that was the first one served on December 23rd, correct?
That's correct.
And that language that you put in there, Exhibit A, is incorporated as though fully set forth herein. Is that the language you just read?
Yes, ma'am.
Right. I'm now going to hand you State's Exhibit 2 to the AT&T first warrant. Can you review that first page, the first paragraph?
Of S2?
Pardon?
Are you seeking the admission of S2?
I am seeking the admission of S2. Just to be clear, Judge, all of these that I'm putting before him and the ones that are attached, we're seeking the admission of.
No objection to S2? All right, it's admitted.
Have you reviewed that, Detective Payne? Do you see that, the language that I just referred to in the search warrant affidavit, do you see that same language in this warrant where you incorporate the affidavit, incorporate Exhibit A into your, you see that language
Ma'am.
in S2? And is S2 the actual search warrant for AT&T?
Yes, ma'am, it is.
Can you turn to the last page on page 4? What time was the warrant served?
10:03 a.m.
Do you recall that the return on that warrant came in at 3:30 that day?
That would sound correct. I don't remember specifically.
Would it help if I showed you the AT&T Mobility Propriety front page to verify?
Yes, ma'am.
Judge, I'm not seeking the admission of this, just for purposes of him being able to be certain. Sorry.
The witness may be shown the document to refresh his recollection.
Yes, Your Honor.
And Judge, for the record, this has also been admitted already in Frank's D17, page 634. Detective, can you see on that that came in at, I think it's 15:30? It's
15:31.
okay. Thank you. I'm now handing you Defense Exhibit A to the reply to the AT&T suppression motion.
This doesn't have a sticker on it?
Pardon?
This does not appear to have a sticker on it.
No, it does not, but it is attached to the reply as Exhibit A, AT&T. And that reply is, okay. Can you see line 4 there? Oh, sorry, Judge.
Copy and put, let's just, do you have a number that we were going to call this?
I would call it Exhibit A to reply, because that's what it is in the record. You see at the bottom of the page where it says Exhibit A, AT&T?
So this is the return of the warrant of S2?
Yes.
All right, let's call it S2.2. Or 2.1, pardon me.
That's fine.
The fact that it's associated with that particular warrant. allowed to touch stickers under the union contract, so why don't you give it to the bailiff?
Detective Payne, on page 2 of that Exhibit A, it's actually just the front page where it says Affidavit of Brett Payne. What does paragraph 4 say?
Paragraph 4 or line 4?
Line 4.
It says the warrant was served on 12/23/2022 by email, fax, et cetera.
So do you know exactly what method was used?
I don't remember.
Okay. And it says warrant in that line, right?
Yes, ma'am.
Does it say anything about the affidavit in support of search warrant accompanying the warrant?
Oh, ma'am.
On the next page, the receipt and inventory of warrant, do you see that?
Yes, ma'am.
Can you look at description of property? What does that say?
It says 509-592-8458.
Can you explain how that's a description of property and what that means?
It just means essentially that there was the information retrieved as a result of that phone number being queried with AT&T.
And it indicates that that was produced how?
Entrance was obtained by email.
And when that was received, did you do anything to verify that the data was within the date ranges of November 12th to November 14th of 2022?
I don't remember. That information was provided to Special Agent Balance as soon as it was received.
Do you have, when you say that it was provided to Special Agent Balance, is that because you don't have the capacity, technical skills, I guess, to review that raw data and do something with it?
Yes, ma'am.
Was there anybody else that you relied on for that, other than Special Agent Balance?
Not that memory brings to mind.
Okay. Let's now turn to the AT&T2 pen trap, and also known as pen trap and trace. Can you explain what a pen trap and trace is?
So, pen register, best of my knowledge, now granted, as I've stated before, I'm not an expert in cell phone stuff, but to the best of my knowledge, a pen register tracks incoming and outgoing phone calls, text messages, so on and so forth. And then the trap and trace is the portion that essentially gives you location data, or the precision location data rather. So it's essentially incoming and outgoing calls, what messages are received, and then part of that was where that phone was located when it was doing it.
Was it required that you secure the AT&T first warrant to obtain the second warrant that included a pen trap and trace?
I don't believe it was required.
So when the data was received on at 3:30, you gave that data was given to Special Agent Balance?
Yes, ma'am.
Okay. And then what happened in between 3:30 and 4:53 when the second warrant was secured?
Are you talking technically speaking, or can I speak in generalities? Because that's all I really know.
Well, I want you to talk about what you know.
So the only thing I know is that that information was provided to Special Agent Balance. He utilized whatever tools he has at his disposal, and then it was decided upon to go after the second pen trap and trace.
When did you start drafting that second trap and trace?
I don't remember.
So on that day, you did one in the morning that was secured at 10:03.
Yes, ma'am.
And then the second one was secured at 4:53 p.m. And you don't have a recollection of when you were working on those?
I don't remember, no.
All right, I think you have State's Exhibit 2 in front of you.
Yes, ma'am.
Can you flip back to that one? Can you see on page 1, what does it say that the time of that warrant was obtained?
Talking about State's Exhibit 2. Oh, 10:03 is what it says. Is that what you're referring to?
No, I'm referring to the return, which should be in, I might be referring you to the wrong exhibit.
Point 1, I believe.
And that was at 4:53. The second warrant was obtained at 4:53. I might not have handed you pin trap.
I don't think I have that one.
Okay.
Yeah, my understanding is, just so we're clear, because I'm getting a little confused, is that we have the
So the affidavit warrant, the warrant, and the return of the warrant all related to the first warrant to AT&T. And we haven't got the pin trap and trace warrant presented yet, I don't think.
Right, I've got it here. And Judge, for clarification purposes too, today as we're going through testimony, my plan was not to go through every single warrant that we're arguing about and get it in front of the court. I'm really trying to take kind of a scalpel approach on the issues that we want to point out to the court. So it does really feel like I'm jumping around, and I realize that. I hope to bring it all together in the end.
We hope so
The
too.
only caveat being what I've told you before is where you have as a broad array of documentation that you've presented, the court will not scour the record to find support for your motions that's not pointed out to the court specifically. And that's well established with case law from the Idaho Supreme Court.
And Judge, that's why I am trying to grab the pieces and parts that I want you to be able to identify, and that's why I'm putting the paper in front of you. So I'm hearing you when you've asked us to do that. All right, I'm handing you State's Exhibit 1. And this is to the second AT&T warrant, also known as Pin Trap and Trace.
This one is also listed as S1 on the sticker.
The sticker.
So that's going to cause some
Oh
problems.
boy,
It's
mislabeled.
S1 attached to a different motion to suppress.
They got the judge all
Well,
confused.
hopefully we can figure it out when we're looking at the entire record, but
And what I think, Judge, when you are going back and working with your clerk.
my concern, frankly, I know what all the documents are and what they relate to.
Yeah.
My concern is a reviewing court's ability to understand what you're talking about in court today and trace it to a stack of documents.
Oh.
That's my concern for this.
The
So-
Leaning Tower of
And
Pisa.
I understand that. And so in preparation for today, I mean, I really did think, do I need to go through and label all of these? And I thought that would create more confusion in the record because these are all attached to specific motions with these labels.
This is marked S1, titled Affidavit for Search Warrant and Application for an Order for Pen Register or a Trap and Trace Device.
Yes.
So on the record, what we're looking at.
So Detective Payne, is that the warrant that, that affidavit in support of the search warrant that you drafted for that second AT&T warrant?
Yes, ma'am.
On page 11, at the bottom of the page, can you read that last sentence under probable cause?
Certainly. In support of the assertion as to the existence of probable cause, the following facts are offered based upon personal knowledge of the affiant. See attached statement of Brett Payne, which is marked Exhibit A and incorporated as though fully set forth herein.
All right, I am now handing you S2, which is the search warrant and order authorizing installation and/or use of pen register trap and trace device and non-disclosure order pursuant to Idaho Code 18-6772. Can you please turn to page 7? Can you see what time that was obtained?
4:53 p.m.
The judge, he looks so not amused.
I'm now handing you what is titled Return of Search Warrant, Exhibit A to Trap and Trace.
Does that have a sticker on it?
Pardon?
Does that have a sticker on it?
No, it does not.
No sticker. He laughed. The judge-
2.2.
What do you call that, Judge?
S-2.2,
S-2.2.
None of these
further delineated by the
stickers.
title, which is related to the pen trap and trace.
Does that have a sticker on it?
On page, can you look at page 2? You see the top, what does it say it's the affidavit of?
Corporal Brett Payne.
Are you looking at Exhibit A, page 2?
Oh, correction, I see what you mean. Affidavit of Lawrence Mowry is what it says at the top.
Right, and then, but is that actually your
It is, yes, ma'am.
affidavit? Okay, so that was a mistake.
Yes, ma'am.
I'm sorry, what were you looking at?
On page 2, the top of it says affidavit of Lawrence Mowry.
Oh, gotcha.
It's the affidavit of Corporal Payne.
A heading problem there.
I'm now handing you Exhibit C to the reply to Trap and Trace. It does not have a sticker, and it says AT&T Mobility Carrier Request Form.
This again relates to the trap and trace warrant.
She
does.
said it doesn't have a
S2
sticker.
4.3. In the next day or so, if you would provide a formal identification list, if you will, of the exhibits that you'd stipulated to admission to yesterday, as I don't think we went through those individually, just so that there's a record of that.
We can do that. Might take us a couple days, but we can do that. Can you look at, are you looking at that Exhibit C, Detective? Was cell site location data requested for this warrant on this page?
Yes, ma'am.
And was a timing advance report requested on this page? I'll refer you to the last paragraph where it says remarks, special instructions.
Yes, ma'am.
And do you see any reference in this document indicating that the affidavit in support of search warrant was included with the warrant?
No, ma'am.
Okay, the next warrant I want to talk about is Apple.
I think so, Lucia. Get over it. Oh my God, the paper shuffles. Fucking perma smile. She's loud.
Prior to this case, had you ever prepared an Apple warrant?
I don't remember.
What was your training related to Apple warrants in December of 2022?
I had no official training at that time.
I'm handing you what's been marked as Defendant's Exhibit A. It does have a sticker, and it's to the Apple motion.
Ministry, your comment.
Can you state what that document is?
Appears to be a preservation request.
And who is it sent to?
Apple Corporate Legal Counsel,
And what's its date? What is the date on it?
December 21st.
Of 2022?
Correct.
And that letter was not sent by you, right?
No, I do not remember sending this, no.
Well, can you look at
That's not me.
Yeah, the top of it is Department of Justice, and the back, page 2 is Special Agent in Charge Dennis Rice.
Correct.
How was the DeSales email account known at that date?
I don't remember.
How did you become aware of an Apple product in this case?
Memory serves, when the search warrant in Pennsylvania was executed, there was an iPad that was located in one of the shared living spaces in the home, and there's a receipt in his vehicle, in Kohberger's vehicle, that was found for an iPad as well.
And during the home search, was the iPad seized?
It was not.
Why not?
It was in a shared living space.
Do you remember what day that the Apple account was created?
I don't remember, no, ma'am.
Does 2016 sound familiar with the research?
That sounds vaguely familiar, yep.
And you mentioned the receipt that was found in his car. Do you recall the date that indicated that an Apple product was purchased?
I do not remember.
Right, I will show you State's Exhibit 1 to the affidavit for search warrant.
in all reality, we need more context on what they've brought up, like the blood on the thing, like the blood on the glove. I mean, someone could have cut their finger and touched the banister. I mean, we don't know. So that's why we need more context on what was found, right? In my opinion.
And I believe it's tabbed, the receipt.
This is State's Exhibit S1, affidavit for search warrant to Apple Inc.
And it's 2018, the date.
Yes, ma'am.
Where did you get the form to prepare the Apple warrant?
The form? Be more specific?
Correct. Well, the search, so you're looking at the search warrant affidavit, and inside of that affidavit is a long list of items that you request.
Yes, ma'am.
Where did you get that information to be able to include that?
That was all provided to me from the experts in that particular field.
I'm just getting S1 in front of myself for a minute here, Judge, so or I'm going to have to give him a different exhibit.
Just so I'm clear, when you said the long list, are you referring to paragraph B on page 2?
On page 2, beginning on page 2,
Is that what you're referring to?
I'm referring to everything A through I.
I'm sorry, was there a question pending? I kind of threw us down a side alley there, so I apologize if there was a question pending that I threw you off from.
No, that's fine. I'm looking for the page here. Do you recall that in your affidavit, there's reference that iOS devices can use an iCloud account to back up the iOS device?
Yes, ma'am. That sounds familiar.
And what's your understanding when an iOS device uses an iCloud to back it up?
Similar to Google and many other of these digital operating systems, essentially they back it up to a cloud account. So that information is stored not on your device only, but also in a cloud storage area. And that's my understanding of it.
And so in an Apple phone, that ends up as creating a duplication of what's on the phone?
Essentially, yes.
And do you recall that in the affidavit you made reference to the fact that Apple users get 5 gigabytes typically of storage and then can purchase more?
Yes, ma'am.
D. I'm handing you what's been marked as Exhibit D it's Defendant's Exhibit D to the Apple Memorandum in Support of Suppression, and it is it does have a sticker.
Right, it's marked Defendant's Exhibit D, date 11/14/24, entitled Affidavit for Search Warrant, directed to Apple Inc.
Can you please turn to page 27?
Help me, I'm confused with the blood. Was it someone else's blood on the rail or Bryan's and someone else's?
The actual warrant itself that you're...
Yes.
Yes, ma'am.
Well, it's, I don't want to answer that as a yes before I look and make sure what this exhibit is.
I want to make sure because my page numbers run out at 25.
It's Exhibit A, and it's to the Apple warrant. It says, so Exhibit D, Apple, the bottom that page says page 27, but above that it says page 23.
Yep, I'm there.
Okay. At the top, it says, on January 27th, Apple Inc.'s Privacy and Law Enforcement Compliance Office responded with the requested records.
I'm not there, so can you...
Oh, I'm sorry.
Are we looking at State...
Exhibit D?
D.
Yeah, page 27
Exhibit E.
of my marking date.
ESHIBITY.
So it says Exhibit D, Apple, page 27.
On January 27, 2023?
Yes,
All right, go
yes.
ahead.
On January 27, 2023, Apple Inc.'s Privacy and Law Enforcement Compliance Office responded with the requested records. Can you explain what Apple responded to?
I don't remember what all they responded to. We responded to the search warrant and all those listed items that were in the warrant itself.
Okay. And the warrant, the date on this, if you will turn to, let's see. Turn to page 34 of the exhibit. Do you see the date of the warrant?
1st of August.
So I understand that you just said you don't know or you don't remember, but in this context, in your search warrant affidavit, you make reference to something being produced on January 27th to process to get a warrant on August 1st. Do you know what the process was that Apple responded to or what they produced?
I do not remember. No, ma'am.
I'm handing you Defendant's Exhibit B to the Apple Defendant's Memorandum in Support. It does have a sticker on it.
All right, the exhibit, just for the record, is Defendant's Exhibit B, date 11/14/24 on the sticker, and the title is Certification of Apple, Inc., Custodian of Records.
Okay. Detective Payne, on this, there's a certification, this document is a certification of Apple Inc. Custodian of Records. Do you see that?
Yes, ma'am.
And it indicates that records are certified and being produced from legal process served on to Apple on January 12th, 2023.
Yes, ma'am.
You see that? What was served as legal process on Apple on January 12th, 2023?
I don't remember.
You know what the legal process would be?
I don't remember what that would have been.
Going back to,
Thank you,
going
LA.
back to Exhibit D. Do you have that one in front of you still?
Yes, ma'am.
Can you turn to page 35 of that?
Yep.
On line 4, what does it say?
The warrant was served by Corporal Payne on August 1st, 2023 via lawenforcement@apple.com.
And so that would have been the Apple warrant, right?
Correct.
And you served it, right?
I believe so.
Well, when you say you believe so, would you have executed an affidavit if you hadn't?
No, ma'am, I just want to make sure on the warrant return itself that it wasn't served by one of the digital forensic folks.
Isn't she a smart ass?
This affidavit is your affidavit, and on line 4 it says you served it, right?
Yes, ma'am.
Did you serve that with a copy of the search warrant affidavit?
No, ma'am.
Was it your practice in serving all of these warrants that where you actually did service, that you would serve the warrant only?
Yes, ma'am.
And then on Exhibit D, page 37,
Okay.
at the bottom where it says description of property, can you explain what the return was for that Apple warrant?
All account information associated data for the following Apple identifiers, and it goes through DSID, Apple ID, V. Kohberger at spartan.northampton.edu, another DSID, and Apple ID, Wi-Fi Army-owns at yahoo.com.
Did you open up the Apple data and examine that?
I don't remember if I looked at what the return, like all the files that were attached were.
In terms of evaluating that Apple data, as the lead investigator, who have you put in charge of evaluating Apple data?
I relied on the specialists in those fields, which would be Detective Mowry and then S.A. Balance. Those are the folks who knew far more about it than me.
Thank you,
And do
LA.
you know, as we sit here today, whose job it is to evaluate the Apple data for this case?
I don't know, ma'am. Not right now.
Okay, the next warrant we will talk about is Google.
Isn't he the lead detective? Shouldn't he know that? I mean, I don't know. Maybe he
I'm handing you what's
doesn't need to
being
know
marked
that.
as Defendant's D to the Google Memorandum in Support of Suppression.
Right, so that I'm clear and the record's clear, this is Defendant's Exhibit Number D with the date on the sticker of 11/14/24 which refers to the sticker date, I believe, not necessarily the document date. And then it's entitled Return of Search Warrant, the warrant being with respect to the application of search warrant for Google LLC. As the other documents that were proffered are admitted.
Did you prepare the Google warrant returns Exhibit D?
Yes, ma'am.
On page 2 of that exhibit, does your affidavit say Detective Mowry served the warrant through a portal?
Yes, ma'am.
How did you know that?
She told me that.
When did you get the return? When you got the return, did you review the data?
I did not, ma'am.
Did you take any steps to see if the return conformed to the warrant?
I did not look at the technical data contained within. I believe it was a zip file that was downloaded from Google, if memory serves me correctly. I downloaded it and made sure that that was there.
And do you recall that there were actually 3 Google warrants? Does that sound familiar? I'm going to hand you now Defendant's Exhibit E. Defendant's Exhibit E to Google memorandum in support of motion to suppress.
All right, Defendant's Exhibit number E, again with the date on the sticker 11/14/24. This is a receipt and inventory of warrant to Google.
Hell, so does the judge. He looks bored out of his mind. I feel like they know this is kind of a
On
waste
this
of time, but I don't know.
document under the description of property.
What do I know?
Can you state what Google account you put in as received?
Zip files for all digital records for the Google accounts of Bryan Christopher at gmail.com and username spelled a bit different at gmail.com.
Did you know that the email in the warrant is actually Bryan Christopher 1994 at gmail.com?
Oh, that sounds familiar, yes, ma'am.
Okay, so on that description, is that a mistake?
Yes, ma'am.
And did you do anything to, I asked you this, but you didn't do anything to verify that the data that you received from Google fit what was requested in the warrant?
Oh, ma'am, not my recollection.
Right, that's it for Google.
Okay. Smile on.
You were in Pennsylvania for Mr. Kohberger's arrest, correct?
Yes, ma'am.
And you watched the preparation for service of the arrest warrant?
How do you mean?
Well, maybe I should ask this more open-ended. Tell us about your arrival in Pennsylvania in time-wise to his arrest, time frame of his arrest.
I believe we arrived there, if memory serves, about 7 p.m. on the 29th. And I think I get my dates right here. We observed final preparations for the SRT operation that was going to take place. And then we, being myself and Detective Gilbertson from ISP, drove to a separate Pennsylvania State Police barracks to await the arrival of Mr. Kohberger.
When you were observing preparations, what were you observing?
I believe we observed their final tactical brief for SRT, and that was about it.
Can you explain what that was like, what the preparations were that they were making when they were doing that tactical brief?
I can give you a general overview, as best I got. So it had their entire SRT that was going to be conducting the operation present.
For the record, SRT is
A special response team, usually what it stands for, Your Honor. So they were doing their final preparations, going over their approach, team member assignments, so on and so forth. This was all done via basically a briefing in front of everybody.
And do you recall that the preparations included that in preparation they were going to knock and announce in execution
I believe that was brought up, yes, ma'am.
of the warrant? Okay. And while you were there, did you go into and have were you given a tour, or did you drive into the gated community of Mr. Kohberger and see where he was living?
No, ma'am.
You never went in or around his home?
No, ma'am.
He said no.
When the execution of the arrest was happening, did you have the ability to listen in any way?
The only ability that we had at the time was a very choppy drone feed. We were driving at the time it happened, and that was the only communication we had.
And so how is that choppy drone feed being communicated to you?
Via cell phone.
So can you explain that? Like, who's the person communicating with you?
Oh my God.
About the drone? I just don't understand.
So essentially, it's a drone operator with their SRT. I remember how it was conveyed, a link of some sort. They dropped a drone, it took off. I got the link, so we could essentially just watch a live feed of what the drone was seeing, and that was it.
Do you know if that live feed was recorded?
I do not know, ma'am.
Did you record the while that was happening? Did you create a recording?
No, ma'am.
What is a Bearcat?
Bearcat's an armored vehicle used in SWAT operations.
And do you know what role the Bearcat? Describe that vehicle again.
So they're usually built on, I think it's like a Ford F-250 chassis. So it's a pickup cab essentially, but it's got a large box compartment in the back.
Pretty
for lack of a better term.
badass.
Usually has portholes on the sides. It's highly up armored to protect the occupants, being SWAT operators. And they usually use them as an approach vehicle, so they have a covered location to deploy from.
Is it a, like a retrofitted military piece of
ma'am.
machinery?
No, ma'am.
It's specifically a law enforcement piece of machinery?
Yes, ma'am.
And it sounds like it's really big.
It depends on what you're comparing it to. I'd say it's no
What's
bigger
big,
than,
lady?
you know, if you were to have a pickup camper on the back of an F-250, something like that.
And what's your understanding of where that Bearcat was parked for the arrest?
I believe the Bearcat, if memory serves, drove up the driveway and just parked in front of the house.
Get out of my head, Kels. What is she getting at here? Look at the judge, man. He can't. He's so animated, like.
I'm handing you what's been marked as State's Exhibit 5 to the motion to suppress, and it was attached to 119 Lambsden.
Really, September. Perfect. Where's that happen in
All
September?
right, this is marked with an exhibit sticker S5. Title of the document is Pennsylvania State
Ooh, it's
Police.
stickered, guys.
Heading with essentially a letter directed to Detective Payne.
Detective Payne, can you explain what that letter is?
That's a justification for reasoning for amending the original plan for knock and announce to a hasty knock and announce and quicker entry into the Kohberger home.
When did you receive that?
I believe this was recently. I don't remember what date.
When you say recently, was it received in response to prepare for today's suppression hearing?
I believe so.
Do you know why Mr. Lang didn't date the letter?
I have to ask him, ma'am.
You'd have to-
And so in that correspondence, he explains that the knock and announce was shortened to announcing from the Bearcat with immediate forced entry.
Yes, ma'am.
Were you present when Detective Gilbert Mirandized Mr. Kohberger at the station?
Detective Gilbertson?
Gilbertson, sorry, yes.
He's on it, y'all.
And that took place after Mr. Kohberger was first seized in his home, right?
Correct.
That also took place after he was transported in the back of a police car to the station, right? You noted in your report that Detective Gilbertson had a recorder in his pocket at the time of the interview.
I believe so.
Were there any recordings that took place at the Kohberger home when entry was made into the house?
I do not know.
Where was Mr. Kohberger's car parked at the time of his arrest?
It was in the garage.
Was it later seized pursuant to a search warrant from that garage?
Yes, ma'am.
And when you said that the iPad receipt was found in the car, is that the car that you're referring to?
Yes, ma'am.
That is all the questions that I have for you. Thank you.
Cross-examination. We have just a moment, Your Honor.
Come on, Jennings.
The state doesn't have any clarifications for this witness.
All right, thank you, Detective. You can step down. Actually, if you don't mind, I actually have a question.
Of course.
You testified that you didn't send the affidavits and support search warrants with the warrants themselves to Google, Apple, et cetera. And the persons that processed the evidence received, would they have knowledge of and access to the affidavit?
Absolutely, Your Honor.
Questions follow up to that?
I do. How would people that are getting an email through a portal, Apple, Google, AT&T, how would they have access to the affidavit?
The question was the people that received the evidence, not the people who sent it. So in other words, the police team that reviewed the
Simmer
evidence, did they
down.
have access to it? Not, that wasn't my
Okay,
question.
I didn't hear you. You do
Just to
have
clarify.
you do have a soft voice, and I am losing my hearing. So then, based on that, how would those folks get access to the affidavit in support of the search warrant when they're reviewing materials?
Just so I'm understanding you, those folks, meaning the people who work for these companies, is that who you're referring to?
No, I think that's not what the judge was
Right, I
asking.
understand.
He was asking that once that evidence is returned and you log it, his question was, do they have access to the affidavit
Hey,
in support of
Jake
search
House.
warrant?
Right.
And your answer to him was yes, absolutely.
Yeah.
How?
There were paper copies of it. It was no secret. It was shared freely amongst the investigative team.
Okay, but not each person reviewing, various people are reviewing these, the electronic data for the some 67 devices and third-party warrant returns, right?
Yes, ma'am.
And in terms of my question earlier, which was I was asking about Apple, who's reviewing that data? Your answer was, I don't know, right?
Yes, ma'am.
So if you don't know who's reviewing something, how would you know that they have access to a search
Thanks
warrant
for your
affidavit?
support, Jake
Well, that's
Hells.
the beauty of having a collaborative team effort. If you share the information freely, it's not independent upon myself to provide that to them. Everybody has that information to reference.
So is in the database that you're creating with this collective, I'll stop this, break this down. My understanding is that the collective document is Exhibit A, correct?
Correct.
And then when you attach Exhibit A to a warrant with
This
Exhibit A
lady,
to a
man.
affidavit in support of a search warrant, you also add additional language depending on who that warrant is for, right?
Correct, yes, ma'am.
So there are over 100 different search warrant affidavits in this case. And it's your testimony that everybody who would have access to doing review of data has access to go in and look at what exact search warrant affidavit was executed?
I believe so, yes.
I have no further questions.
Follow up from the state on that. All right, thank you, Detective.
Judge, I think we don't need to step away, but I do need a break to organize my documents
Just watch you.
for the next witness, who will be Detective Mowry.
Mike,
Give
one of my
to
staff had the
Malou.
opportunity to take a break. They'll be back in a second, so we'll just get them sworn in and we'll wait for them.
Okay, this is Detective Mowry. This is Lawrence Mowry.
Do you solemnly swear affirm the testimony you're about to give now before the court is the truth, the whole truth, and nothing but the truth? I do. Thank you.
And I think it's fine if you just want to start with his, if you're going to ask him his background, you can do that.
Good morning. Detective Mowry, could you please state your name and spell your last for the record?
My name is Lawrence Mowry, Mowry.
What's your current job?
I am a forensic detective with the Moscow Police Department.
And could you tell us about your background in law enforcement?
I have 14 years of law enforcement experience in the state of Idaho. I've been with the Moscow Police Department for the last 6 years in this current role.
What is your role in this case?
I was, put in charge of, lead, I don't know. I was the one that was looking at and funneling the excessive amount of digital data and evidence that was coming through.
Have you taken on any other roles in this case? Have you had other duties?
If you're asking about serving warrants for digital evidence, then I've done that, yes.
And you've heard, Judge,
Yeah, you're fine. Go ahead.
Okay. Do you agree that the Exhibit A that's been discussed was and attached to warrants, that was a group effort?
Yes,
Have you been a part of that group?
I was.
What role did you have in the first AT&T warrant?
I don't recall specifically. I was there when it was being discussed.
You recall that you served that warrant?
I do.
When you served that warrant, did you serve it with the search warrant, with the affidavit in support of search warrant attached?
No, ma'am.
Is it your practice to ever serve an affidavit in support of search warrant with the warrant?
No, ma'am.
Were you co-located with Special Agent Nicholas Balance as well?
Yes, ma'am.
What was the distance that you had in proximity to him?
He sat in the same lab that I did.
And so was that a cubicle setting? Can you describe the setting?
It's a secured forensic lab. It has a door.
And then
A door?
inside, is it open? Were you in separate offices?
It's a single room.
Single room. And so you were literally in the same room with Agent Balance?
Yes, ma'am.
And was that for the entire time that he was co-located there?
Yes, ma'am.
Were you aware of his ability to have access to AT&T records without a warrant?
No, ma'am.
FYI, Mr.
All right, I want to talk now.
Agent Balance was also the digital forensic analyst in the Daybell case. Random fun fact.
About the cell phone, also known as the USB. Do you recognize that? But I should say, I'm so sorry, because there are so many cell phones. Bryan Kohberger's cell phone. I want to talk to you
The
about.
physical cell phone or the data from the cell phone?
We're going to talk about both of those. So for purposes of today's argument, we've called it cell phone / USB. How did the state come into possession of Bryan's phone?
Obtained via the warrant in Pennsylvania.
Was a copy of that phone made prior to the search warrant being signed?
Which search
Copy
warrant?
of Bryan's cell phone.
Again, I'm asking which search warrant. You're talking about the one from Pennsylvania or the one that we requested once the data returned?
I'm talking about when it was first seized, so it'd be the first.
The Pennsylvania one?
Right.
I do not know.
You're aware that a copy of the phone was made and put on a USB,
Yes.
and then a warrant was obtained to search the USB.
Yes, ma'am.
And that's the second warrant.
Yes, ma'am.
Was the cell phone searched prior to the warrant for the USB?
The extraction was created before the warrant in Idaho was requested.
Was the extraction searched before the warrant was obtained in Idaho?
No,
And how do you know that?
I was the one that received the extraction.
The extraction, where was the extraction made?
Pennsylvania.
And who made that extraction?
I believe it was Special Agent Tanzola.
And how did Special Agent Tanzola get that extraction to you?
You'd have to ask him. I believe it was using a Cellbrite product.
So what about is the USB not a physical box of the extraction, or is it all digital?
The USB is just a storage device that the data would be placed onto.
So with the extraction and the USB, can you explain the process of the extraction being made and it getting to you and it getting put on a USB?
Welcome, new members.
Normally, in a forensic environment, the device is extracted, that extraction, and then therefore be placed onto a different storage device for evidence storage or for sharing with other forensic investigators.
And so you said normally, but I'm asking you specifically to Bryan Kohberger's cell phone.
The data was placed on a storage device by S.A. Tanzola and provided to me.
And how did you get the storage device?
I believe it was brought back. I don't recall how I was given to it. It was still in the FBI packaging.
Do you have any personal knowledge of whether or not Special Agent Tanzola reviewed the data of the extraction before the search warrant in Idaho was obtained?
I don't recall.
Okay.
Like a fajita, jammers. Like a fajita. The chapstick. Dude, Crumbly's in court January 31st, and I'm here for it.
Judge, this is one you don't have yet either. This is Defendant's Exhibit A to cell phone. And it does have a sticker on it.
And it does everything.
Do you have an extra copy of that?
Pardon?
Do you have an extra copy of that?
No, did I handed two, right?
Yeah, and just going forward, I need 2 copies.
I will. I heard that message yesterday, Judge, and I apologize. Moving forward, I will make sure that there is that extra. I'm assuming you went up for your
Whoopsie
clerk.
daisies.
Well, staff attorney,
Yeah,
yes.
yeah.
Whoopsie daisies.
Oh, I got some great lighter.
And just for the record, as I've been doing this, has been marked Defendant's Exhibit Number A with a date on the sticker of 11/14/24. The document on which the sticker is placed, first page is affidavit for search warrant, directed to the Moscow Police Department Forensic Lab.
Detective, how did you create the affidavit in support of the cell phone of the USB warrant?
How did I create it?
Yes.
Guess I'm not understanding. That's a vague question.
How did you go about drafting this? Is this a document that you had, that you filled in from, or did you start from scratch? How did you
I
come
don't
up?
remember the exact way that I did it, but it's not. This isn't very different from, say, an ICAC warrant that I would have had previous intentions to search the cyber chip information that would be already placed into evidence at the Digital Forensic Lab.
This lady's wild.
So when there's knowledge about what you're asking for and a list of things to get, what are you basing that knowledge on?
I would be basing this on information that I've done in previous cases, other warrants that I have served, and other warrants that I have viewed from other investigators throughout my time.
Can you turn to page 24? You see that page?
Yes, ma'am.
And is that page entitled Search Warrant?
Yes, ma'am.
Looking at the first paragraph of that search warrant, is there any reference to search warrant affidavit in the warrant?
No, ma'am.
And is the date of the crime on the search warrant?
No, ma'am.
On page 25, can you turn there? There's a directive to search the premises. Do you see that?
Yes, ma'am.
What's the premises listed as?
155 South U in Moscow, Idaho, in the Forensic Lab. 155 South of U, one word.
Does it say USB in that
yeah.
descriptor?
My calligraphy pen.
Yeah.
Fuck.
Can you turn to page 28?
She's so she's so snippy.
Who is Key Computer Forensic Lab?
Key is not a person, it's a thing. It unlocked the secure cubicle that the USB was placed into by myself, so that it was
Who
secured.
is
I had
it?
the key, and entrance was obtained by Key in the Computer Forensic Lab.
Okay. That makes sense now. I thought it was the name of a company, and I don't know why, but that makes sense.
Oh, she was all saucy. Listen.
So that it was a secure thing. It unlocked the secure cubicle that the USB was placed into by myself.
Listen
so that it
how
was secured. I had the
saucy
key,
she was.
And entrance was obtained by Key in the Computer Forensic Lab.
Okay. That makes sense.
I had the key.
Who's Key Forensic Lab?
Can you turn to page 28? Who is Key Computer Forensic Lab?
Key is not a person, it's a thing. It unlocked the secure cubicle that the USB was placed into by myself, so that it was secured. I had the key, and entrance was obtained by Key in the Computer Forensic Lab.
That makes sense now. I thought it was the name of a company, and I don't know why, but that makes sense. Key Computer Forensic Lab. Who was ultimately in charge of searching the USB drive?
The data was extracted, or not extracted, but reviewed by several different people.
Okay, who are those people?
I don't know all of them. Myself
Anna.
looked at some of the information, but not all.
And you said you don't remember all of them, but who else do you remember?
The information was also given to the FBI. The FBI had that information, and they examined it.
And do you know who with the FBI?
No, I do not.
They literally thought. They literally thought that was some kind of forensic lab that she was going to catch them. Like they were going to catch them using. Who's Key for Computer Forensic Lab? Who are they? Where's their credentials? Oh, man.
Can you turn to page 27? Can you look at page 6? Or not page 6, I'm sorry. Number 6, line number 6. Do you see that? What does that say?
A copy of the warrant inventory sheet were left with the drive.
And that does not indicate that a copy of the search warrant affidavit was left with the drive. Is that right?
No, ma'am.
Okay, I want to talk now about Amazon. Did you swear to several warrants for Amazon?
I did.
Do you know specifically how many?
I do not recall how many.
How were the warrants served? How did you serve Amazon warrants? How were the warrants served? Do you know specifically how many?
I do not recall how many.
How were the warrants served? How did you serve Amazon warrants?
I believe that Special Agent Michael Douglas assisted in service of those.
What training do you have in Amazon accounts and records?
I do not have any training for Amazon specifically.
I worked
And I
there
think you
last
answered my
season.
next question, but there was a reference in the warrants to a special agent locating an Amazon account. Is that the Special Agent Douglas?
I don't recall who was that, who found that information.
How was an Amazon account located?
I don't know.
In your affidavit, where you've got language that talks about what Amazon holds and how it identifies and the list of items that can be collected, if you don't have any training in doing an Amazon warrant, how did you know that? To put that?
I was relying on the experts that have worked with or served the warrants to Amazon previously. I believe that information came from Special Agent Michael Douglas.
Michael Douglas.
And in your affidavit, did you indicate that that was based on your knowledge or on someone else's knowledge?
I based it on mine because I spoke to Special Agent Michael Douglas about it, and he was the one that informed me that this was the information that we could request.
And so did he provide you with a kind of a mock-up affidavit to use so that you would know what language to include?
I don't remember if he gave me a mock-up, but obviously he would have helped me with the wording of it.
The wording of the warrants is pretty technical, right? All the list of items that is asked for.
Any electronic service provider usually has their special way of asking for things.
And so since you don't have training in Amazon, you relied on Special Agent Douglas for that?
Yes, ma'am.
Okay, Google is the next one I want to talk to you about. What's your training about Google?
Again, I have no specific training to Google. I've served various email or warrants on Google for other means.
Is your experience with Google isolated to this case?
No.
You've done Google warrants before?
Oh, yes.
How did you get the form that you used for the Google warrant in this case?
The Google form, I probably relied on previous warrants that I've served.
Do you know how many warrants you obtained for Google in this case?
It's 3.
On January 3rd, that January 3rd, 2023, that warrant asked for Brian Christopher, 1994 at Gmail, 2 phone numbers, and an IMEI number. What's an IMEI?
International Mobile Equipment Identifier?
And how did you get that number to put in the January 3rd, 2023 Google warrant?
I do not recall.
Okay.
Lisa. Hey, truck you. The judge is just over it, I think. Friday, he's over it. Come on, lady. God almighty.
Specifically about these warrants?
About being able to get the data via warrants?
I don't recall communicating with them specific to these warrants.
Okay, I'm going to hand you what's Defendant's Exhibit F to the Google Memorandum in Support.
Fine.
You recognize that?
Appears to be an email between myself and a Francis from Google.
So is this how you were communicating with Google via email?
I was communicating with Google for other, I'm not sure if this is the one for this specific warrant, I guess is where I'm getting at. There was question of what Google could provide. We served Google at one point with a warrant. They said it was, they couldn't do it because there would be too much data. So they were trying to assist us in, well, basically not spending $100,000 of getting them data.
So to be clear, when I'm talking about the communications generally, I'm talking about your communications with Google about all the warrants. So was there email and telephone communications or just email?
I believe I spoke with their legal representation on the phone. I don't remember if there was other conversations.
Do you understand the difference between a personal account and a not personal account on Google?
I do not.
Okay. Well, there's reference to DeSales and DeSales helping from their end. Can you explain that?
I don't recall what that means.
Do you recognize what DeSales is in the course of this case?
It references an email address that was associated with the defendant.
Okay. And that email address associated with the defendant is a college that he attended, right?
Yes.
And so was there communication with DeSales about them not wanting to produce records pursuant to a warrant because it was educational records protected by federal law?
I was part of a little bit of that. Officer Detective Payne knew more about that conversation, but yes.
And so what I'm trying to understand is what was DeSales doing to help?
I believe DeSales was just waiting for a warrant. I don't recall completely.
And did you serve the Google warrants?
I believe I did.
I believe you said you did?
Yes.
And consistent with what you've said earlier, you did not include an affidavit in support of search warrant with that? Why did you choose the timeframe of January 1st, 2021 to December 30th, 2022?
Good question.
I don't recall the specific reason why we went back to January 1. It was to include the time that we believed that the defendant had entered Washington, to become a student nearby the crime scene, and just prior to that.
Okay. But you know that he didn't come to Pullman, Washington until June of 2022, right?
Correct.
Did you review the Google warrant return emails?
Yes.
Did you review, so you said you reviewed them. Are you the one who's in charge of evaluating those materials for this case, or is that designated to somebody else?
The materials came to myself, at which time it was disseminated to other investigators and the FBI as well.
Is it fair to say that between warrant 1 and warrant 3, it's gone from 2 gigs to over 13 gigs of material?
It was substantial information.
And have you done anything to verify whether or not the materials produced are within the scope of the warrants?
I usually made sure that they were from that specific account when it's received, but I did not go into depth of the evaluation.
Let's talk, the final area is about the Apple warrant. What was your role in those warrants? In that warrant, sorry, not plural, singular.
I don't remember that specific one. I know I was involved in a lot of the Apple iCloud warrants.
Ooh, let's hear about his iCloud.
What kind of communications did you have with Apple to facilitate getting the warrant?
I don't recall prior to.
I'll hand you what's been marked as Defense Exhibit C to the Apple warrant. It does have a sticker on it.
Next, we're going
And
to have
it's not to the
scratch
Apple
and
warrant, it's
sniffs.
to the memorandum in support.
Scratch and sniffs and
Exhibit
puffy
C
stickers.
attached to their memorandum dated, exhibit sticker dated 11/14/24.
Fucking Garfield puffy stickers.
Appears to be a
What are those
printout of some emails.
Hey, Bella. You want a Garfield puffy sticker for the exhibities? Did Ann? No, Ann's
Have you reviewed those?
been
Can you,
working.
does that help refresh your recollection regarding what communications were occurring?
It appears that there was communication between Apple and FBI.
Okay. And were you included in that?
I believe I was.
Okay. And did that include chats,
I believe the word chat means to chat, to talk.
like telephone talk or Zoom talk, or what was the method?
I believe it was telephonic.
So what kind of help were you getting from Apple, and what was the FBI getting from Apple?
I don't recall the conversation. This was more specific to the FBI's current
I
investigation.
do.
As I stated in my email there for the stalking investigation, I was merely just privy to their conversation.
Wait, what? Wait, what?
Have
Just
all of their materials related to that been,
the stalking situation?
FBI's current investigation.
so what kind of help were you getting from Apple, and what was the FBI getting from Apple?
I don't recall the conversation. This was more specific to the FBI's current investigation. As I stated in my email there for the stalking investigation, I was more specific to the FBI's current investigation. As I stated in my email there for the stalking investigation,
The FBI was conducting a stalking investigation? Is this in conjunction with the Idaho 4 or what?
I was specific to the FBI's current investigation. As I stated in my email there for the stalking investigation, I was merely just privy to their conversation.
Have all of their materials related to that been turned over?
Who's there in that sentence, Counsel?
Pardon?
Who's there in that sentence?
Sorry, FBI.
I do not know. I wasn't, I don't know.
I have no further questions.
Ooh, did you guys catch that? Oh boy.
Specific to the FBI's current investigation. As I stated in my email there for the stalking investigation, I was merely just privy to their conversation.
So then she doesn't want to say stalking investigation again. And she just simply says, so have all the records pertaining to that, or have they turned over all the records pertaining to that? She doesn't want to say it again. Thank you, Bella. Thank you, Bella. Today's an off day. Wow. Wow, 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 wow. Let me go back a few. I want to actually record that and clip it. So let me hit record. Here we go.
Communication between Apple and FBI.
Okay. And were you included in that?
I believe I was.
Okay. And did that include chats,
I believe the word chat means to chat, to talk.
telephone talk or Zoom talk, or what was the method?
I believe it was telephonic.
So what kind of help were you getting from Apple, and what was the FBI getting from Apple?
I don't recall the conversation. This was more specific to the FBI's current investigation. As I stated in my email there for the stalking investigation, I was merely just privy to their conversation.
Have all of their materials related to that been turned over?
Who's there in that sentence, Counsel?
Pardon?
Who's there in that sentence?
Sorry, FBI.
I do not know. I wasn't, I don't know.
I have no further questions.
Ooh-wee. He says, I wasn't, and then he stops like I wasn't part of that.
Can I stay here? Okay. Just a few follow-up questions.
She asked if she could stay at the
When
desk.
you received the evidence back from these various providers, did you have access to what we refer to as affidavit for search warrant and Exhibit A?
Yes.
Okay. And did you use that to determine
like,
the
no.
scope of what you would be searching for from those providers?
If I was to be doing the investigation, yes, I would have looked at those items.
And you testified that several investigators helped MPD in review of evidence back from providers.
Yes.
To your knowledge, did those investigators have access to the affidavit and the Exhibit A?
Yes.
I don't have anything further. Thank you.
You redirect.
No, Your Honor.
Thank you.
She said, "Can I stay here?" He said, "No."
I have no further witnesses.
All right, why don't we take a 10-minute recess, and we will then pick up.
So, is there more to today? Oh my gosh, that was pretty wild, huh? Stalking investigation. So we just finished. Oh, there is one more. Okay, let's see how long this one is. I think we can get through it, don't you guys? It's not even 7.
Kohberger, defendant is present. Counsel are all present. I'm heard.
This will probably
there are
take
no more
about
witnesses to present by
40
either party. Is
minutes.
that accurate?
Hey, Hensley.
Yes.
All right, we'll move to argument then. The defense may proceed.
Ooh, we got captions too.
Judge, I'm going to cover several of the warrants, and then Mr. Logson's going to cover 4. So I'll just wrap all of my argument up instead of getting up and down for each one. My oral argument is not meant to rehash every point briefed or every argument briefed. I'm giving you big picture comments based on the testimony, but I want to make it clear that we're not waiving any written arguments. While I questioned Corporal Payne and Detective Mowry about some exhibits, but not all, it was not an indication that others are not important. I wanted to make important points, but not to belabor. With IGG and Franks having been addressed yesterday, and the fact that the primary issues that I'm addressing have to do with general warrants, I'm not going to rehash those arguments, and I'm going to focus on the legal issues, beginning with the AT&T Warrant 1, Pen, Trap, and Trace, also known as AT&T 2, and the cell phone/USB drive. The Fourth Amendment requires particularity sufficient to prevent the exercise of discretion by an executing officer. The particularity requirement's objective is that necessary searches should be as limited as possible. A search warrant must be particular enough so that, as to what is taken, nothing is left to the discretion of the officer executing the warrant. The government cannot seize the haystack to look for a needle, and there is an undisputed privacy interest in cell phone data, including cellular site data pursuant to Carpenter. All 3 of these warrants were issued in December 23rd and early January 2023. The 2 AT&T warrants were issued on December 23rd, 2022, within an hour of each other. The first did have a temporal narrowing. AT&T 1 had November 12th, 12 a.m. to November 14th, 12 a.m. The warrant itself was extremely broad and did not incorporate the affidavit. In support of this actual failure to incorporate, the officers admitted that they did not incorporate in the search, but to the extent that the state is going to argue that when the warrant says upon offer and proof, that is the same as hereby incorporates an affidavit, I pointed out the language in certain search warrant affidavits to show you that they do know what it means to actually use the language herein is incorporated Exhibit A, and that same language is not used in a single search warrant affidavit. So the incorporation that would be a remedy for this issue, potentially of particularity, doesn't exist when the search warrant affidavit is
This
not included.
lady's voice,
Even if, for
holy
some reason, you were to determine that there was English language meaning upon proof,
Where did they
and
find
oath
her?
is the same as hereby incorporated, the language in the search warrant affidavits themselves is extremely broad. The affidavit of return signed by Detective Payne's, this is on AT&T 1, says that the warrant was served by email, and as he indicated, it did not include the search warrant in support. The description of the property in Exhibit A to AT&T described the property as just a phone number with no other description of the property, which indicates a lack of knowledge of what was actually seized and going to be searched. The second AT&T warrant and install pin trace was requested within 1 hour of the first warrant return at 3:50. The data from Warrant 1 was analyzed such that by Special Agent Balance, such that Detective Payne was relying on Balance in his affidavit to support it by saying that the data that had been in their hands for less than an hour supported that the phone was possibly off going south on Pullman at 2:42 a.m. And there is just got to be a question for everybody of how does this massive amount of data get analyzed in an hour to create a second, broader warrant? The warrant language in AT&T 2 pin trap trace is extremely broad, and the time frame goes from June 23rd, 2022 to present. The crime of homicide was stated, but the date of the crime was not stated. There was no other specificity in the actual warrant. The warrant asked for extensive data, location data, timing reports, cell tower information, and installation of a pin trap and trace, among other many things. And when the warrant was served, a check the box form was included as a cover sheet to AT&T. Turning to the cell phone is first seized when Bryan is arrested. It's copied by Special Agent Tanzola without a warrant, and then that USB drive makes its way to Idaho in an unclear fashion. It sounds to me like it came back with Corporal Payne, who was there for the arrest. And when that warrant is obtained for that USB drive, it's put in a safe with just a copy of the warrant that has no date of the crime, and there's nothing particularized about what is to be searched. This creates a general warrant with 100% total discretion and nothing to limit the search. And if you believe that access within a database by somebody unidentified other than Mowry, who's going to evaluate that warrant, that they're going to look and pull that finalized search warrant from the database that everybody supposedly has access to, looking at that search warrant affidavit, there's full discretion to search the USB drive. There's no limitations and no efforts taken to address that. Turning now to Google and Apple. A very instructive case on Google and Apple is the Idaho killing case, which is 721 F Sup 3D 1113 2024. It's almost totally on point with this case. It is a federal case out of the District of Idaho, but it really couldn't be more instructive in terms of looking at these issues with Google and Apple. There's without a doubt a recognized protected interest of private information in Google and Apple records. Google contained private emails, schoolwork, research among things, and Apple was essentially a copy of a phone and iPad that went all the way back to 2016. 2018 was an indication of when an iPad was purchased, but 2016, according to the documents that were prepared, were when it was identified that an Apple account was first created. Carpenter applies, and to the extent that there may be third-party materials like search history not related or documented, nothing was done to do any sort of segregation with regard to Apple or Google. For the Google warrant, by January 3rd, 2023, law enforcement knew many details that they could have used to narrow those warrants. They knew that Bryan hadn't been in Pullman until June of 2022. They knew the names of the deceased, which were not included as language in the Google warrant. They knew the fraternities and sororities. They knew the students' names who had also been at the house on the morning of November 13th, 2022. They knew the date of the crime, of course. They knew emails. They knew social media accounts and names. They knew where students worked. They knew their friends. They knew their phone numbers. None of that was included in the Google warrant to help limit and make that something other than a general warrant. There's no language incorporating these search warrant affidavits, making these broad, sweeping categories, making the productions bigger and bigger. In Google, it went from 2 gigabytes to 13 gigabytes by the third production. And it appears that it's really unclear to these detectives that have taken a huge role in this case who's evaluating what data and to what extent and what is being produced by it and what is within the scope of what is in an already broad warrant. For Apple, we are missing some sort of legal process that the state just hasn't filled the gap on, and these witnesses don't fill the gap on. We don't know what the legal process is that is referenced between the first request for a preservation in December 21st, all the way until August, when there is a production on a warrant. The steps that have been taken in between to get the information to put into the warrant are completely unclear, and to the extent that these officers who swore to the contents of affidavits now have no memory of what that is, that's invalidating of those warrants. As for the arrest and the car and the apartment, what I will close by saying on those, because it's not an issue of general warrant or a discussion of particularity. Those are more reliant on the issues associated with IGG and Franks. And with that, I'd ask that you find that the warrants that I've just discussed are general warrants, not particular warrants, and they should be suppressed.
Do you want to respond to that, or do you want to have the defense argue the additional warrant issues and then address them all?
I'll take your lead, but I'm happy to just to piecemeal this, and I can address just those.
Okay, Ashley.
I can make this pretty simple for the court. We don't have to go down the rabbit trail that the defendant would like you to go down.
Got
The
that
search
right.
warrants regarding the particularity requirement. In this group that we're talking about is Apple, AT&T, there was a first and a second, Kohberger's phone, and then Google. All of these warrants were not general warrants. They were all sufficiently particular. They were specific to the type, each one of them listed that they were specific to the type of crime, the location, and all but one of them had temporal limitations. And for the one that didn't, that would be the cell phone warrant. That warrant was more particularized in the types of data that officers were allowed to search for. It's the state's position these were not general warrants, and your court can determine that just by looking at the face of the warrant. If you have any questions, otherwise, state submits, you should deny the motions to suppress for these issues.
Your Honor, I was asked to argue the motion regarding the raid on my client's parents' home, the search of his person here in Idaho, as well as in Pennsylvania, as well as and the Amazon warrant. I think for the most part, I'll just rely on the briefing. I just want to clear up a couple of things. One of the areas that was covered in the Pennsylvania home raid was that the state had to have a valid warrant in order to enter the home. I think in the briefing it gets a little confusing, but the point was not that Mr. Kohberger couldn't have been arrested as he was walking down the street via the usual channels in which that could have occurred. the point was that they had to have a valid warrant in order to get into the home. The only warrant that they have is the one that we're challenging via the Franks motion. And so that was the purpose of that argument. The other issue in terms of choice of law, it sounds like the state's kind of accepting that Idaho Constitution should apply. We set out a few different reasons why that should be the case. It doesn't seem like there's a big argument going on there, so unless the court has questions about it, I'll leave that alone. And then the other issue that I wanted to touch on is the right of privacy in the information that we have in our Amazon goings about why should the state have to have a warrant for that. I thought we set it up pretty well in the briefing, but I think the big concept and takeaway here is in Carpenter and Riley, the United States Supreme Court starts doing something different. And I think what the court is starting to recognize is that to a great extent, the United States has become a sort of panopticon. That is, the concept of the panopticon is you have a prison in which you only need a small number of guards because you have a very heavy-duty surveillance system. In the United States, we have via our phones, via the internet, much of what we do is now surveilled and very easily accessible. And so the fact that we have the third-party doctrine made sense when it was being adopted back in the 70s and the 60s. It stops making sense once all of this information is easily accessible in the way that it is. And so our point is that the judiciary has to have a role in this. There has to be a judge between us and the executive. Otherwise, we're essentially allowing the executive to know everything about us all the time. And so the state makes the point that, similar to the one that Professor Kerr made about going and getting bank materials, once those were things that could be done simply and efficiently via these records, a person didn't have to go out and get the cash. The state argues in this case, because of Amazon, Mr. Kohberger didn't have to go someplace to purchase items. All of that would have been out in public. He's doing it on his computer, and so why should that make it private? And the reason why that has to become private, Your Honor, is because of the vast amount of information that is now so easily accessible to the government. If we don't require a warrant, we essentially put all of ourselves at hazard of being snooped on at any time. And so I also just want to briefly bring up, I think yesterday the court had talked about privacy rights with the IgG databases, and I certainly want to make sure that we are preserving that argument. We included it in the briefing. We do believe that Americans have a privacy interest in the genetics they share with other people, and that other people then place within these databases. So that is not something that we intended to abandon in any way yesterday. If the court has no other questions for me, I would rely on the briefing.
Thank you.
Thank you.
Your Honor, I'd like to address just the third-party doctrine, and then I'd like to turn it over to Mr. Thompson to address the other motions to suppress. And the case that we're talking about is the Amazon records, and that's what has to do with the third-party doctrine. And the U.S. Supreme Court case State v. Miller is the controlling case here. And Idaho courts, as explored in my briefing, apply Miller. And there's no reason for this court to diverge from that Fourth Amendment analysis. The documents are Amazon's business records. They detail transaction history. Business records are most akin to bank records, which is allowed.
Bank
Applying
record.
the court's reasoning from Miller, again, these documents are business records of Amazon. They're not the defendant's private papers. Amazon is a party to those transactions. They have a substantial stake in these records, and the defendant took the risk when he revealed his affairs that this information would be conveyed by Amazon to third parties, including the government. It's the state's position, and it should be the position of this court, the defendant does not have a Fourth Amendment privacy interest in Amazon's business records. Thank you, Your Honor.
Good morning, Judge. I'm going to address, I guess, the remaining warrants or the questions raised by the defense about the remaining warrants. I'd like to start first with the warrants for the residents in Pennsylvania. That expands into Mr. Kohberger's person under the Pennsylvania search warrants for his person, for his car, which was in Pennsylvania, and then the defense also raises questions about statements made by Mr. Kohberger to law enforcement. First, as to 119 Lamson itself, one of the first things the defendant offers to the court is claims that there was no local warrant, valid local warrant, and that simply isn't true. As the record clearly demonstrates, there were 3 valid local warrants, Pennsylvania warrants, for the residents, for the defendant's person, for his car. The defendant then asserts, and I appreciate Mr. Logston's clarifications, but essentially the defendant asserts there needs to be a separate special warrant in order for Pennsylvania to take the defendant into custody as a fugitive from Idaho on our charges. And as we cited in our briefing on this, the statutes in Pennsylvania and Idaho are virtually the same, and they clearly contemplate that a felony fugitive can be taken into custody without a fugitive warrant under the circumstances that exist in this particular case. Now, if the issue is the law enforcement presence or access to the defendant inside his parents' residence, we would submit that's already addressed because Pennsylvania State Police had a valid search warrant for the premises, for the defendant's person, and for his car. So they had lawful process to be where they were when they found the defendant and took him into custody as a fugitive. The knock and announce, there was discussion earlier today in the explanation of what happened with the dynamics of the knock and announce. That's detailed in Sergeant Lang's statement, which now has a current cover affidavit to it filed with the court. But that's S5. I'm not going to publicly go through all the factors unless the court wishes me to because they are quite incriminating as far as the applicable factors that justify either an abbreviated knock and announce or, frankly, elimination of knock and announce entirely. And from what we have before the court now, it's clear that the Pennsylvania police were operating in a dynamic sense, reacting to real-time information that was coming in. That's all documented in the various reports and log sheets that have been submitted with our pleadings, which are not particularly lengthy in nature.
Finally, as to the defendant's statements, I think the key notion here on any statements the defendant made, and frankly, he really didn't make much in the way of incriminating statements, is there was never any interrogation. He was Mirandized eventually, but even the prior conversations that occurred with Pennsylvania law enforcement, there was never interrogation. And so Miranda is not implicated, and so there's no issue on the statements themselves. As to his car and his person, as I've already mentioned, there were valid specific Pennsylvania search warrants for each of those, so those are presumed to be lawful. There's been no substantive attack on those. There is a motion to suppress regarding, and I'll use the air quotes, arrest warrant, and frankly, I have yet to be able to figure out what arrest warrant is being referred to. But again, all the actions in Pennsylvania were taken pursuant to valid warrants, search warrants from the Pennsylvania courts, and the applicable fugitive
doesn't know what
arrest
search
statutes. And so
warrant
we don't see that there's any issue before the court there. The defense also raised the issue of a search warrant for the defendant's person in a separate motion, which appears to be the search warrant for the defendant's person here in Idaho when he was returned to Idaho. And as the search warrant and the affidavit for the search warrant show, which were attached to our reply, there was a valid search warrant for that. I think any issues to be argued beyond that relate to the ITG and Franks that are already pending with the court. As far as the defendant's, the search of the defendant's apartment in Washington, for whatever reason, the defendant did not include all the documentation with their particular motion to suppress, but we provided that in our response, that there was a Washington search warrant. There was also an amendment to the Washington search warrant. The Washington search warrants, the applications, included all the information, the Exhibit A information from the state, and then the WSU Police Department added their additional state of Washington specific information. There's nothing to question the validity of that warrant on its face. So, Your Honor, unless the court has questions, I don't have anything further to offer in the way of argument, oral argument. Thank you.
Thanks, sir. Thoughts on any rebuttal?
I think I just rely again on the part. In terms of the knock and announce, I think the totality of the circumstances of this particular raid are something that the court has to be cognizant of.
He's so quiet.
Dylan Roof could essentially be picked up in a parking lot outside of a drugstore or whatever it is that they were able to do.
Facts about which I have no idea, and so it's not going to be helpful to compare it to
Well,
whoever Mr. Roof is. So
I guess the point is that in this particular case,
Wait, what did he
the state
say?
manufactured the
whoever Mr. Roof is.
drugstore or whatever it is. If Dylan Roof could essentially be picked up in a parking lot outside of a drugstore or whatever it is. If Dylan Roof could essentially be picked up in a, or something that the court has to be cognizant of. If Dylan Roof could essentially be picked up in a parking lot outside of a drugstore or whatever it is that they were able to do.
Facts about which I have no idea. And
Fuck did he say? If Dylan Roof, but I know that's not what he's saying. What is he saying?
so it's not going to be helpful.
Essentially be cognizant of this particular raid or something that the court has to be
What is he
cognizant of.
saying?
If Dylan Roof could essentially be picked up in a parking lot outside of a drugstore or whatever it is that they were able to do.
Facts about which I have no idea, and so it's not going to be helpful to compare it to
Well,
whoever Mr. Roof is. So
I guess the point is that in this particular case, the
Who's Mr. Roof? What the fuck? I was like, what? I thought it was like a business, like Mr. Roof. Fuck, what are these people talking about?
and so it's not going to be helpful to
Yeah, but he's like, I don't know what you're talking about.
or something that the court has to be cognizant of. If Dylan Roof could essentially be picked up in a parking lot outside of a drugstore or whatever it is that they were able to do.
Facts about which I have no idea, and so it's not going to be helpful to compare it to
I don't think that's how you cite case law. I don't think you go up there and go, if Dylan Roof had da 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 da. I think you're supposed, and I don't know nothing about it, but I've heard enough for them to go, oh, citing, so and so versus Roof when this happened, da 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 da. He's like, oh, well, Mr. Roof would have done this. Dude, who are these people? Are these people fucking actors or what? This is weird.
What you are witnessing is real. The participants are not actors.
I think the totality of the circumstances of this particular raid or something that the court has to be cognizant of. If Dylan Roof could essentially be picked up in a parking lot outside of a drugstore or whatever it is that they were able to do.
Facts about which I have no idea, and so it's not going to be helpful to compare it to
Well,
whoever Mr. Roof is. So
I guess the point is that in this particular case, the state manufactured the exigencies, if they had them at all. The reality is, as they explained in their own affidavit, they're essentially watching Mr. Kohberger as he moves around his house via snipers. I mean, they were quite safe, and there was simply no reason to bash the doors in momentarily after yelling from their Bearcat.
there's two issues. There's officer safety. There's also destruction of evidence concerns.
In the cases that we cited, Judge, when the claim has been that there's evidence being destroyed, the evidence, what's known to the officers is something along the lines of, they hear somebody running away after they announce themselves. It's not typical that the police simply don't knock and announce at all. In those cases, they usually give the person the opportunity to surrender, but it's not a particularly long one. And in this case, they don't do that at all. And the only thing they knew is that he's walking around from room to room and that he has some kitchen gloves on. And I don't think that equates necessarily to the destruction of,
Well, that's not all they knew, but I won't go into the detail in order to preserve so as that we don't go into those issues.
Thank you, Judge. But beyond that, we'll rely on the briefing. Thank you.
Okay, Logston, go walk back to your seat.
Take the motions to
Look at
suppress
him.
under advisement and issue ruling.
Look at Logston. He walks like a penguin.
But beyond that,
Watch him waddle back. His feet are like a penguin. Watch.
we'll rely on the briefing. Thank you.
Okay. Take the motions to suppress under advisement and issue ruling forthwith. The next issue is the
Holy
state's
shit.
motion to compel regarding the defendant's expert disclosures.
I'm sorry, Your Honor, the defendant's motion to compel the
Did I say the state's motion to compel? The defendant's motion to compel regarding the state's expert disclosures.
We did file ours yesterday, so their motion may be coming.
Well, I would be impressed if they had filed something already on that, given they were just served yesterday afternoon, so.
They will. Thank you. Your Honor, we are here on our motion to compel, asking that the court remedy what the state has done with their expert disclosures. We rely on Idaho Criminal Rule 16 and the court's order setting out what we should do and when we should do it in this case.
Let me ask a question from a framework standpoint. I don't know what these folks are going to testify to at trial, specifically as it relates to what they've disclosed. The way expert disclosure issues usually works, I don't tell a party what you have to specifically disclose about your experts. You disclose about what you think you need to disclose. If you haven't disclosed it consistent with the rule and you try to offer it, there's a good chance it may not come into evidence. That's the general framework, so I'm a little, I guess, concerned about what appears to be you asking me to tell them what to say in their disclosures.
The court brings up a really, really good point, and I think it's a remedy the court has and one that we would hope and ask the court to issue in this case. I think when we filed the motion, Your Honor, we had a couple of disclosures that could appear to be disclosures with wiggle words in them.
Yeah, wiggle words are not going to save the lack of disclosure. I'll let the state know that right now. The fact that you say, well, you can talk about anything else, doesn't mean he's going to get to talk about anything else.
In an abundance of caution, we were worried about those words. I appreciate what the court's saying, and I'm going to make this.
Oh, did you? Oh, he told her. Wiggle room.
Case. I think when we filed the motion, Your Honor, we had a couple of disclosures that could appear to be disclosures with wiggle words in them.
Yeah, wiggle words are not going to save the lack of disclosure. I'll let the state know that right now. The fact that you say, well, you can talk about anything else, doesn't mean he's going to get to talk about anything else.
In an abundance of caution, we were worried about those words. I appreciate what the court's saying, and I'm going to make this really short. The lists are problematic for us. There are 4 or 5 experts with lists. I understand what the court said. I like what the
They
court
also
said.
have reports that they reference.
The lab people do have reports. I understand those are their opinions. When we're talking about, and I'm going to specifically talk to you about their disclosure number 7, it's an FBI agent, Douglas. There's a list of financial records that he collected and looked at. Other than that those records exist, there's not a report telling me what they mean to him at all. If he's limited to say, I collected these records, this is what we have.
Well, I understand the state can correct me is what I understand from the briefing is with respect to that. I think that's the Amazon documents, correct?
Those were some of those documents, Your Honor. There are a lot of others.
Was his expertise was in extracting or reviewing the information and how those were sort of obtained electronically and then simply guiding through, well, this is a transaction on this date that does this, which is not necessarily expert testimony, it's simply testimony.
No, but I believe it's a different expert that they have to do that does not have a report.
But is that expert testimony? Let's just say Mr. Kohberger on X date purchased a television, if for some reason that were to be important, and that this transaction demonstrates that this is Mr. Kohberger's account, this is Mr. Kohberger's credit card, and this is the purchase on Amazon. And that was delivered to this address associated with Mr. Kohberger.
Those are factual issues, Your Honor. It's when we get to what do they mean, or I put these things together and I've made this picture out of something. That when we get to opinion, I appreciate what the court's saying. It sounds to me like lists don't do it if you want to interpret a record. That's what we hope to hear. That's what I wanted to accomplish today.
Well, I think it's pretty clear. You cannot simply say an expert's going to talk about topic A, topic B, topic C, and then be able to give a host of opinions that fall within those topics. The requirement is to list what their opinions are and what they relied on to give those opinions. It's different than the civil rule. I don't think they have to give as much detail as the civil rule requires, but they have to at least give what the opinions are, and I believe what they reviewed, as I recall the rule off the top of my head.
I believe the court's about right. There may be another term or two in the rule that's specific, but I hear the court loud and clear. I'll point out one last thing, and
Read the room,
stop
baby.
because I think I understand how the court interprets these issues and these rules. When you look at page 9 of the state's objection to our motion, and in the second to last paragraph, they tell you that they will continue to supplement their expert responses based on later discovery or whatever they decide to use. That whatever they decide to use has me worried. So I wanted to bring that up. I appreciate the court saying the court's going to apply the court rules and the discovery rules and follow the case law, and that's all we want. Thank you.
And so that I'm clear, as the state's approaching to talk about this, in terms of supplementation, it's allowed. It needs to be seasonable, which means it has to be not just whole cloth new experts, for example, without good cause showing me why that's necessary. It needs to be seasonable in the sense of the timing of it based upon when the information was received, when it was determined it was necessary to supplement. And then obviously we'll look at that in relation to what may prejudice the other side in terms of the timing of it.
Certainly, I understand that. Their discovery deadline has come and gone. If something brand new happens, that would be a different issue. I assume we would deal with that then. It's when I read whatever we decide to use, that's very, very broad. That's it, thank you.
He's like, thank you. All right, Miss Jennings, you're up.
I can keep this pretty short. I don't think that there's really much in dispute at this point. State's position, we've complied through our expert disclosures with Criminal Rule 16b7, as well as your court's scheduling order. State understands the framework that you've outlined. We were under the same impression, and I don't think that there's anything else in dispute.
Yeah, so let me give you a word of caution. Sometimes there's dissonance between what an expert thinks that they're going to talk about and what the lawyer understands from that expert. And the lawyer submits these disclosures. And I think it's really important that you be on the same page if you don't have a specific written report from the expert about what it is they're going to talk about, and make sure that you have supplemented and that you have provided a listing of the opinions that are going to be provided and whatever else is required under the rule in terms of what that's based on. And I would encourage both sides to over-disclose those opinions in caution rather than under-disclose. Because two things. One, you may find yourself in a bad position if you're not allowed to go into an opinion you felt you were going to be allowed to go to because it's not disclosed. And two, I don't want to spend half our day at trial with me saying, where's that disclosed at? And then chasing the jury out while you dig through your thousands of pages trying to find where that is. And so the more exhaustive your disclosures, the less likely it is it's going to draw that objection, and the less time that we're going to waste at trial trying to find where you disclose that. And so I think sometimes, and I'm not saying you did that in this case, I think sometimes lawyers view this expert disclosure requirement as sort of tedious work that they need to get done in order to comply with the timeline, a requirement of court, and then they sort of move on from it and forget about it. It's a dangerous tact to take. It is, for the case, one of the most important things that you can do is to understand what the person is going to testify to and give a disclosure of what they're going to testify to, what those opinions are. And to be looking at that as you're thinking about their testimony, as you should be doing, certainly now, even though it's months away from trial, on a continuing basis. So I would really stress the importance of that in a case, particularly of this import. And so don't feel like your job is done at this point, because I would suggest to you it's not. That you may consider needing to do some cleaning up and making sure things are more fulsome in the scope of those disclosures and what you're doing. The other thing, I think you tried to do to a degree is you thought, well, we think this is fact testimony, but, in an abundance of caution, we're going to put it in an expert disclosure. Well, if you're going to put it in an expert disclosure because in an abundance of caution it could be viewed that way, I suggest you treat it that way in terms of what you give. Okay? Thank you.
Damn.
And that goes to both sides. I haven't read your disclosures yet, so I don't know where that stands, but certainly goes to both sides. And I know that also, the rules are different as to what the defense has to disclose necessarily and what the state does to some degree, and so I appreciate that.
Well, I think the court will anticipate that there's a rather large filing that contain a lot of actual reports. Your Honor, listening to the court's comments and understanding where we were a moment ago when we spoke, I feel like I must go through what their disclosures were because there are so many lists. My hope was that they would be limited because they didn't fulfill their disclosure requirement, and we did, and that put us at quite a disadvantage, not knowing what their experts would say.
And if they supplement, you certainly can supplement based upon what they supplement, and I will permit that, and that's kind of the nature of the beast.
I do appreciate that, and should that become necessary, we'll definitely take you up on that, Your Honor. I want to make a record about some of their expert disclosures, though. All of the lab people, they have lab reports and notes. The Idaho State Police Forensics Lab, I better be really clear on that. Other than the wiggle room language, which would ask that they not be permitted to have any wiggle room language, the lab reports are fine, with the exception of one of the witnesses, Ms. Nowlin, that they've disclosed, and she's written no reports.
Is that the one they said is a rebuttal witness?
They said she might be a rebuttal witness, so I suppose now they know what our witness is going to say. I want to talk about the CAST report. The court's heard a lot about the CAST report. When I say CAST report, that's because that's what it's called. It's really a PowerPoint presentation. There's not any analysis in that. There's just, this will be my testimony. This is what it's going to be. Without much more, it's a picture, and it has some dots and some arrows. Your Honor, that needs to be cleaned up. We need to understand the analysis that went into coming up with those PowerPoint presentations. That's just not plain good enough. I would let the court know that the cell phone experts, there's wiggle language in both of those if the court hasn't seen that. Their disclosure number, that's Mr. Cox. That's a person that has not written a report at all. We have no idea besides the state's disclosure what that person's going to talk about. Agent Douglas that I talked about before, I don't think I need to make further record. There's a lot of documents, no analysis, no opinion stated. We put several of these in our pleadings, and so I won't go through all of them. I'm highlighting the ones that we're really concerned about. We have 3 that looked at digital data. The court should understand there's 60-some devices. There's digital data from third-party sources, and there are 3 people that are listed with just lists of things. It's Mallory, Tanzola, and Uric. They have lists of devices or social media accounts that they're going to talk about. That our expert told us would take 3 years to look at every bit of the data. So having no clue what's going to happen, I can envision exactly what the court's fear is when we get to jury trial, me wondering if this particular thing was ever disclosed. So I definitely needed to make a record of that. Further, with the lab personnel, there's a caveat that says they'll talk about other people's reports and other things that are outside of their report, in addition to some of the other wiggle language that I referred to. Your Honor, given that the state is now cautioned to think about those things and submit more, I feel like it's important for us to bring out that we have a right to confront the evidence that's brought against us. Bryan has constitutional rights, United States and state of Idaho constitutional rights for a fair trial and to confront evidence. The expert disclosures are designed to advise us of what the state is going to do. Their disclosures were insufficient. I appreciate what the court said, but exactly what the court's worried about will happen if we don't have better disclosures. The jury will be in and out and in and out while we make sure that we have a clean record. We appreciate what the court said today, and we'd ask the court to order the state to comply or for the court to exclude anything that hasn't been disclosed so far. That's it.
So I'm going to give like both sides an example of what I expect. So you understand, there's been talk in this case about DNA. If somebody's going to talk about DNA and your intent is they're going to let the jury understand what DNA is, and essentially going to do a mini course on DNA, I expect to see that in expert disclosures. Not that they're going to do a mini course on the DNA. I expect to see the mini course in the disclosures, if that makes sense, in terms of what their opinions are, what their information is that they are conveying that is expert in nature. And so it really does behoove both sides to spend the time to do that. And that's the last I'll say about that. It is probably the most critical thing that you have to do at this point prior to trial is to ensure that you have not just disclosed, but potentially over-disclosed those opinions and what is required by the rule. All right, is there anything else with respect to those?
Your Honor, is the court giving the state a new date to fix their disclosures?
I'm not giving either side a new date. You understand, I think, what I expect. So you can choose to try to supplement those. If they are simply expansions of what it is that they've disclosed that are just being more fulsome, I'm probably not going to have a problem with that, given where we're at in advance of trial, and the defense certainly can look at those and decide that they want to expand or change or whatever their opinions are based on that. If it's whole new stuff, then you're going to have to demonstrate to me, new opinions, new lines, or even new experts. You're going to have to demonstrate why you didn't get that in the timeline.
Thank you.
Okay, is there anything else that we need to take up today?
Nothing from the defense.
I don't know whether we're going to have a Frank's hearing or not. I need to go and do that. But if you don't mind emailing some dates that you have available in the next, say, 3 weeks to do that in the event that we need to do it, I would appreciate that. Okay? All right. Well, I appreciate everybody's work, not just for the hearings this week, but in this case in general. And I know how busy you all are, and I hopefully have not taken more of your time than is necessary. Travel safe. Thank you.
All right, please.
Wow. This judge ain't going to play. Dude, this is going to be a good trial. I like him. I like him as well. All right, guys, I'm going to wrap this one up without further ado. Thank you for listening. Thank you for getting caught up with me. I appreciate all of you. Thank you for the new members. I'll see you guys over on the second channel tonight and around 8:30, 9 o'clock, the latest. Let's run our credits and then dance it out. I'm throwing up a short about the stalking investigation. All right, bye guys. See you later. Thank you so much for watching. If you enjoyed this live stream or video, make sure to give it a thumbs up and hit that subscribe button so you don't miss out on my latest content. Want to take it a step further? Bring it all in. And join our community clickers by becoming a Patreon or a YouTube member. You'll get exclusive access to our Discord server, special channel perks, and much more. Until then, I'll see you in the next one.
Click, 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 click. It's real easy, man.
I don't give a damn. I don't really care about you and your problems. I don't give a damn. You talk way too much. I have heard enough about you and your problems. I don't give a damn. I don't give a damn. Damn, damn. I don't give a damn. Damn, damn. I don't give a damn. Damn, damn. I don't give a damn. You wanna be with me. You wanna feel something real, but I'm feeling differently. You're making plans to get to friends, but don't wanna face the fact that I ain't got time, I ain't got time, I ain't got time for that. Staying up late, sleeping all day, dreaming about Cadillacs. Buying new shoes, hanging by the pool, sipping on Coke and Jack. Calling my phone when you feel alone, but I'll never call you back. 'Cause I ain't got time, I ain't got time, I ain't got time for that. don't give a damn. I don't really care about you and your problems. I don't give a damn. You talk way too much. I have heard enough about you and your problems. I don't give a damn. 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 You're mad at me for not giving you comfort. You say that I'm away so much and now you don't feel the way you felt when we were younger. But that's okay for me, 'cause